Good morning, all. This trial is in the matter of CFI 041-2024 and is being held by way of video conferencing before Her Excellency Justice Sapna Jhangiani, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Monarch Legal Advisory. Lead counsel is Mrs. Serena Mani. The defendants are represented by Fatima Hassan Al-Shahi, advocate and legal consultant. Lead counsel is Mrs. Nikat Sardar Khan. Thank you, Your Honour.
Thank you. Good morning to everybody. Thank you very much indeed to the parties for submitting a revised trial timetable. Firstly, may I please ask lead counsel how they would like to be addressed? If we start with claimant's counsel.
Good morning, Your Honour. I'm happy to be addressed as Serena, if that's okay.
Serena, or Ms. Mani. Your last name is Mani, is that correct?
Yes, I'm happy either way.
Thank you very much indeed. And defendant's counsel?
Your Excellency, if you, I'm happy if you address me as Nikhat or Mrs. Khan, whatever is easier.
Ms. Khan, is that acceptable?
Yes.
Thank you very much indeed. Right, I note that we have time now for some housekeeping. I just want to say, in relation to the trial timetable, as I mentioned, I'm most grateful to the parties for cooperating to prepare it. We do have plenty of time, and I'm not going to be strict on time. If we end up having slightly longer hearing from the witnesses, I'm prepared for us to make the time available during the course of today, since we do have the day. Now, the first order of business is to discuss preliminary matters. There's 2 points I would like to raise. One is the pending application from the claimant that was issued on the 24th of April to exclude the defendant's witness evidence and reply to witness evidence. The second point I'd like to raise is that I notice on the trial timetable, it's indicated that we'll have confirmation of agreed issue. I'm not sure what that meant and whether there was any confusion as to what the issue is. I'll just pause there for a moment in case of any comments on what I have just said, and in case there are any other issues that we need to raise in housekeeping, because I note that another point that's mentioned is bundle references. So, Ms. Mani, if we could perhaps hear from you on the housekeeping matters.
Yes, Your Honour. So the claimants would like to point out that throughout the course of the preparations for this hearing, the defendants have not followed the court orders in a timely fashion. There was a court order to say that the witness statements should be exchanged on the same day. We obviously sent our witness statement across at the due time. We did not receive the defendant's witness statement until several days after, which meant that they had sight of our statement and were able to revise any statements or evidence that they wished to produce, which would jeopardize, it detriments our client. We've set out the full details in the application. To save time, I don't want to go through it again. But if you would like me to, I can do.
That won't be necessary. Thank you.
Okay, thank you.
Were there other points to raise? Bundle references, confirmation of agreed issue. I wasn't sure what those 2 items were referring to.
I believe that we're quite happy with the bundle referencing. Perhaps Ms. Khan would, if she would like to raise any objections with it, then we're happy to listen.
Thank you, Ms. Mani.
Thank you, Your Honor, and my colleague. The thing is that we noticed that the first bundle comprises of around 557 pages, and the second bundle, which was filed yesterday, comprises of 1,422 pages. Definitely, the referencing is going to be different. So what I believe to solve the situation is, and there are many repetitive documents which could have been, arranged properly and to avoid this. So what I propose is that whenever I am referring to the 557 pages, the first bundle, I will say so that, okay, I'm referring to this. At least in my opening statement, I'm going to refer to the 557 pages. But for the cross-examination, I will refer to the 422 pages, which was filed yesterday, if it is fine with you.
Ms. Khan, thank you so much for raising that. It's very helpful to know. I should mention to you that I have only downloaded the latest bundle. I reviewed the earlier bundle, but in the work that I have been doing this morning, the bundle references that I have are from the revised bundle. I do accept that there is a lot of duplication, but so be it. That's where we are. If you wish to refer to the earlier bundle, that's not an issue, but I should mention to both of you, I find it particularly helpful when you're referring to documents, whether in your oral submissions or in relation to the examination of witnesses, I would find it most helpful if that document could be shared on the screen. And if we proceed in that way, then it perhaps should not matter what the references are. I have most of the references of the key documents from the latest bundle, and if I have any issue finding any documents that have been referred to from the earlier bundle, I shall certainly let you know and ask for any help I need. But I think that it will be sensible if we proceed in that way. Is that acceptable to you, Ms. Khan, if we have screen sharing?
Absolutely.
Thank you. Ms. Mani?
Your Honour, the way I've set up my IT today is I have a separate computer with a different access to the bundles, and then a different computer for this video conference, so that I can, switch between the screens. I'll need to, if I was to do that, I will need to, move either the video conference onto the other computer, so it's all on the same PC. But I would just
That's not an issue. That's not an issue. I don't want to cause you any last-minute inconvenience, Ms. Mani. The other way we could do this is I have the newer, later bundle open on my screen. If necessary, I could share documents if that's needed. Are you referring to the later bundle or the previous bundle?
I will be referring to the previous bundle, but I would just like to point out that we did share the bundle well in advance to try and agree the bundle and the referencing, but we didn't receive any cooperation with that to avoid this issue at the time.
I understand. We are where we are. So you are referring to the earlier bundle.
Yes, Your Honour.
How were you proposing to take the witnesses to documents if you weren't able to screen share? Were you expecting we could just manage by reference to the earlier bundle references?
Yes, Your Honour. I was assuming that everybody has a copy of that bundle, and that's how we would refer to those.
Right.
If you think, I can change the IT structure around if it helps the court.
Again, I don't want to inconvenience you. Would it help if we gave you a few minutes to organise that?
Yes, Your Honour. I think that might be best for everybody.
It would be terribly helpful for me if we had screen sharing, and I think it would be very helpful for the witnesses as well. Why don't we do that? Other than dealing with your pending application, is there anything else that needs to be dealt with by way of housekeeping?
Not from our side, Your Honour.
Ms. Khan?
Yes, from our side, I had sent an email to the claimant's counsel yesterday requesting the names of the witnesses they wish to cross-examine, so that because you see there's only one witness statement at our end, and in that witness statement, it has 3 statements of other witnesses. So I just wanted a confirmation from the counsel that whether they intend to cross-examine those witnesses, but I received no response. And I repeated again, and of course, I did send an email late in the night that I would be cross-examining her witness.
Right. Ms. Khan, let's just unpack that a little bit. You mentioned, and I think I did see in the trial bundle, there is one witness statement from the first defendant which attaches
3 other defendants.
other witness statements. Is that
Yes.
correct?
Yes.
It's a very unusual way to file witness statements. We don't need a covering witness statement for witness statements. That's not usually the way that we file witness statements. Now,
Your Honor, it's really unfortunate it had happened, but I just would say that if I was there in the picture, it wouldn't happen.
I understand, Ms. Khan. Right. It strikes me just as a preliminary view that not all of the witness statements that have been put forward by the defendants are relevant to the preliminary issue. But I will pause there for a moment to turn to Ms. Mani. May I please confirm which witnesses put forward on behalf of the defendants you are planning to cross-examine?
Yes, Your Honour. So from our side, we didn't receive this email. We don't have, we can't find it at the moment. If it was sent, it may have been sent out of hours. And obviously this morning the hearing was at 9, so we may not have seen that. In terms of the witness evidence, we would expect that if a witness statement has been provided, those witnesses will be attending. Otherwise, that evidence is hearsay. But as you correctly pointed out, some of the witness evidence is not relevant. So what we would suggest that is if the defence would like to rely on that evidence, then they should present those witnesses and we can cross-examine them if they wish to rely on that evidence. If they feel that it's not relevant to today's preliminary hearing, then we don't need to raise an issue, and that evidence can just be excluded as hearsay.
Ms. Mani, in terms of relevance, and I'm happy to hear from Ms. Khan on this, but I don't see how the evidence of Mr. Nicola, who was the first buyer that your client entered into a share sale and purchase agreement with, is relevant to the preliminary issue. So my personal view is I don't think it's going to be necessary to hear from him. Out of the 2 remaining witnesses, are you prepared to cross-examine them, and would you wish to cross-examine them? That's really the question.
Yes, Your Honour, we would. If
you'd like to cross-examine the remaining 2 witnesses. There's actually 3 witnesses because, as pointed out by Ms. Khan, the first defendant did issue a witness statement in relation attaching the 3 witness statements. So I think, are you, can I just be clear though, in relation to those 3 witnesses, the first defendant and just looking for the names of the other witnesses, Mr. Kuchin and Mr. Grigorev, are you planning to cross-examine all 3 witnesses?
Yes, Your Honour.
Thank you. Ms. Khan, you have your answer. Is that clear?
Yeah, but I doubt the timetable, which was, I could say that, where I'm not involved in it. And I did send out an email during the day regarding the timetable also, that it's not realistic. If you want to examine the witness, you need to tell me the number of witnesses so that we can adjust accordingly. But I'm fine. We will work our way through the day.
Well, as I mentioned, and I specifically mentioned, with a view to the number of witnesses to be examined, we are very flexible on timing today. And so if we need more time for cross-examination of witnesses, we only have 30 minutes provided for the claimant's witnesses and, well, the claimant's witness and the defendant's witnesses. There's not going to be any issue in extending that time. Okay. I've made clear I don't think the evidence of Mr. Nicola is relevant. And I just want to make sure there's no issue with that from the defendant's point of view.
Absolutely.
Thank you. Okay. Now, I should also mention, if we're likely to take up longer in the timetable dealing with the cross-examination of witnesses, I have very carefully read the skeleton arguments and the entire trial bundle. So I have a very firm idea of what the parties' arguments are and which items of evidence they rely upon. And in light of that, it may not be necessary for opening submissions and closing submissions to take 30 minutes on for each party respectively. So you can assume that I've taken on board all the points that have been made in written submissions, and we can perhaps be very brief in opening and in closing. You may need longer in closing, given that we have a number of witnesses, but certainly in opening, I hope that we could shorten that time. Now, the only pending point now is the claimant's application, the second application, to exclude the defendant's witness evidence and the document entitled Reply to Witness Evidence, which was submitted by the defendants. Ms. Marnie, I'm not going to accept that application, and for exactly the same reasons as the claimant's earlier application to exclude the defendant's witness evidence was rejected. In relation to the witness statements, as mentioned in that earlier order, ultimately, I think it will be helpful to the court to hear evidence from all the parties on the preliminary issue. I do understand that it's incredibly frustrating when a party does not comply with procedural deadlines, particularly when if you're a party making an application to exclude evidence, you have complied with the deadlines. And I do understand the point about unfairness. Having looked at the witness statements that have been submitted by the defendants, it doesn't strike me that they have responded in detail to the evidence that was submitted by the claimant. So I think in terms of levelling the playing field, I do understand the claimant's concern that the defendants had an opportunity to review the claimant's witness statement before filing their own evidence. If there is any unfairness that I think arises, I will make sure that we do our best to address it. But taking everything into account, sorry, I know there's an echo. I'm going to give you a minute in a moment, Miss Marnie, to sort out your IT issues.
Please let me.
This echo will be there if there are double speakers in the same room.
I've turned it off. Sorry, I was trying to
very much indeed. Thank you very much indeed. So the claimant's application to second application to exclude the evidence of the witness evidence of the defendants is not accepted. And I do also take on board the point that the document entitled Reply to Witness Evidence is not a reply witness statement. It's essentially submissions. But we are at the point of the trial of the preliminary issue, and my preference is simply to keep it on the record and treat it as submissions, just as submissions in the same vein as the party's skeleton arguments. So that is how we're going to proceed for today. We will keep in the bundle and on the record the defendant's witness evidence and the document entitled Reply to Witness Evidence. Now, I think that's it now for all the housekeeping issues. Ms. Marnie, how long do you need to arrange yourself so that you can screen share? Is 5 minutes sufficient? 3 minutes? How long do you need? No pressure.
Me, probably 10 minutes, but I have an assistant. It might take him 5 minutes.
Wonderful. Well, it's 9:27 a.m. for me. Let's log back on. Let's all stay logged in, but let's adjourn the hearing just for 5 minutes for you to get organised. Okay, thank you.
Thank you.
Yes, Your Honour. I've managed to get the bundle onto the same screen. I'm just going through the bundle with the new page references, so I can refer you to the right page reference.
That's fine. Don't worry about page references, because as I mentioned, for all the main documents, I have page references and I can always look them up. So as long as I know what the document is, it will not be difficult for me to find the documents. As long as I know which document you're referring to, and it's for that reason that I'd like to have the screen sharing. So I think we're ready to start again. Before we go into the claimant's opening submissions, I just have a couple more points I want to raise. The first is that in the trial timetable, there's a suggestion that after cross-examination of the claimant's witness and the defendant's witnesses, there'll be judicial questions. It makes much more sense if I raise any questions while the witness is giving evidence. Once they've been cross-examined, at the end, if I have any questions, I will ask them then, rather than questioning all the witnesses at once during judicial questions. That's the first point. The second point is that I noticed in the defendant's skeleton argument, there was a reference to the claimant's husband giving a statement. And I have to say, I found that confusing and I wasn't sure what that was referring to. I don't know if either of you can enlighten me on that. Miss Marnie?
Your Honour, we don't know what that refers to. There is no witness statement from the claimant's husband.
Thank you. Ms. Khan? Are you on mute, Ms. Khan?
My apologies. I believe that when I was informed that in one of her evidences where she's providing a document, those documents are actually that of her husband. So that is something. This is what was brought to my attention.
Certainly. Well, because I don't know what that document is and I couldn't follow it, if that does remain part of the defendant's case, then in due course you can explain that reference and take me to the necessary document. But as of now, that I don't fully follow that point, but thank you.
Sure. Thank you.
Right. Over to you, Ms. Marnie, for your opening submissions, bearing in mind what I said earlier. If we could try and keep opening submissions on each side to 15 minutes, that will give us more time for examination of witnesses. Thank you.
Thank you, Your Honour. I won't take the whole of the 15 minutes. The preliminary issue is a very simple one, whether the shares were paid for or not. It is the claimant's position that the shares were paid for. There was a resolution passed very early on allocating shares to her. Payment was duly made in cash. A document, instrument of transfer was signed for, and then the shares were recorded on the DIFC public register as having been paid for and allocated. There was no document to say that they were unpaid for. There was no demand for payment. For all intents and purposes, the shares were paid for and were treated in that way. Right up until our client decided to sell those shares and gave notice of those shares being sold on the 3rd of June, I believe. And on the same day, those shares were revoked without any prior notice. The first time she heard of the non-payment was on the 4th of June, one day after the revocation had already occurred, which is in breach of any articles and company law, so therefore it doesn't really follow that a low value shares of $1,000 US, would not have been paid for by our client, and she's intended to sell them. She's gone through the process. She's followed all the process. It doesn't follow that she wouldn't have paid for those. It doesn't. It's on the balance of probabilities. It is likely that she paid for those. because she was treated as a shareholder. No demands were ever made. It's only after she sold the shares and identified that to the defendants that this issue of payment was raised. So as far as we are concerned, that's how simple the matter is, really, Your Honour.
Thank you very much. Thank you. I don't have any questions. Ms. Khan, I think we're ready to hear from you on your opening submissions.
Thank you, Your Honour, and my learned colleague. I would definitely not be so short because I wouldn't submit the skeleton argument that was submitted. So
I'm so sorry to interrupt you, Ms. Khan. Just so I'm clear, am I correct in understanding what you're saying, that you did not draft that skeleton argument? No. Is that correct?
No.
Right. Okay. So you'll be, I mean, the point of skeleton arguments really is to indicate to the court the arguments that lead counsel will be making at a hearing. That's really what the point of skeleton arguments is. But I understand that what you're saying is what the skeleton argument that was filed is not going to be a summary of what you wish to address the court on. Is that correct?
It will be more structured, I should say.
Right.
I will not deviate from it because this is something that has been shared with the parties, particularly the claimant. So I'm not going to deviate, but it will be more organized, my opening statement pertaining to the skeleton argument, which will be focused.
Well organized and focused submissions are always appreciated. So please continue.
Thank you. I trust that you have received the skeleton argument and the reading list, and I propose to structure my submissions in 3 parts. First, a brief introduction to the parties and the defendant's position, which is missing in all the written submissions, which should have been there. And secondly, I'm going to address the application of the framework to the evidence before the court on this preliminary issue. And third, a brief legal framework under the DIFC company law and the Articles of Association. Now,
so I'm so sorry to interrupt you, Ms. Khan. Let me just pause for a moment. Mm-hmm. In relation to DIFC companies law,
okay.
Remember, the issue we are here to determine is whether or not the claimant paid $1,000 for the shares that were allotted to her on the 7th of January, and then the transfer was revoked. I've checked all the provisions that have been relied upon by both parties in DIFC company law and also in the Articles of Association. I'm happy for you to refer to them in the context of whether the shares were paid for, but I'm not sure we need a comprehensive framework of DIFC companies law. That's the first point. In relation to the background of the parties, your part 1, please by all means do address the court on that. But please assume, as I've mentioned, that I have read every single document in the trial bundle. The only document that's been submitted by the parties that I've not been able to review is a video that was relied upon by the claimant that I was not able to review in the trial bundle, and we can see later if it's necessary for me to review that or not. But you can bear that background in mind when addressing me on the background to the parties. Thank you.
Absolutely. My submission will be totally on the preliminary issue because the skeleton arguments on points which are not relevant will not be addressed, at least in this opening statement. So if I may continue. The claimant, Ms. Anastasiia, is a business executive who at all material times served as a commercial manager of Magic Flash, a subsidiary of the second defendant, Real Estate Holding Limited. She also acted as the second defendant's representative for public relation purposes with responsibilities related to external positioning, promotion of a real estate brand, and as such was projected as a senior executive. It is understood from the first defendant that her engagement was terminated around May 2024. The first defendant, Mr. Aleksei, is the founding shareholder and authorized signatory of the second defendant, Real Estate Holding. The second defendant, Real Estate, is a private limited company operating as a holding company located within the DIFC, operating as an AI-driven real estate investment platform. The license copy is available at page 447 of the old bundle, the first bundle filed. The matter listed today for determination is for a single, narrowly, precisely defined preliminary issue pursuant to the case management order, whether the claimant paid for 10,000 shares in the second defendant's company. The defendants respectfully submit that the claimant, Ms. Anastasiia Denisova, did not pay for the shares in question. Her claim is not only unsupported by any credible evidence, but also stands in direct conflict with the statutory requirement under the Articles of Association, which I will address briefly. I do appreciate and respect that, yes, as you pointed out, Your Excellency, that the provision of the law is limited to address this issue. But we understand that there is one provision that could be exercised by the defendant, and that has been exercised. Now, regarding the alleged payment for shares, the claimant has consistently maintained her position through various email correspondences exchanged between the counsel. Specifically, on 16th August, the claimant's counsel asserted this position that she paid cash USD 1,000 on 30th January. This is reflected in many places in the old bundle, and I can reference page 193, including page 4 of the particulars of claim, page 254, which is a repetition, and page 357, I believe, is also a repetition of the document, as well as the recent case memorandum agreed by both parties at page 325, which states that she has made the payment on 30th January 2024. Now, when the defendants provided in the statement of defense a confirmed flight booking at page 255 of the bundle, showing that Mr. Aleksei was not present in the UAE between 28th to 31st January. And he also provided an immigration report that could be found at page 344 of the old bundle, confirming his absence in the UAE during that period. Accordingly, it would be impossible for the first defendant to be physically present in Dubai to receive cash on 30th January as claimed. Subsequently, the claimant revised her account for the first time in her witness statement at page 424 that the cash payment occurred on 23rd January 2024 at the second defendant's office. However, there is no evidence to substantiate this assertion, and we will address this in the cross-examination. There is no receipt, there is no acknowledgement of payment, no supporting communication, no record of cash transaction that has taken place on that day. The defendants submit that the material shift in the claimant's narrative was made only after being confronted with irrefutable evidence that Mr. Aleksei was not present in the UAE. Now, this is an example, we believe, is of a party adjusting the account to fit inconvenient facts to support the contention. Regarding the signed instrument of transfer, the claimant then relies on two documents, which I found at page 19 and 21 of the bundle. The first is a shareholders' resolution dated 7 January 2024, which is located at page 19, which records the allocation of 10,000 shares to the claimant. And second is a pre-filled instrument of transfer found at page 21 of the bundle, dated 30 January, which refers to the sum of 1,000 as good and valuable consideration. The claimant now asserts that the instrument of transfer dated 30th January provides, which recites the consideration that was provided. However, this document does not constitute an independent verification of payment. It is a standard instrument, and a mere execution cannot be regarded as a conclusive evidence that the stated amount was in fact paid. To draw a simple but relevant analogy, in the UAE, when an employee's visa is cancelled, he is required to sign a declaration confirming receipt of all dues. However, when those dues remain unpaid post the signature, the courts do not treat the signed form as definitive. The employer remains under legal obligation to prove actual payment. If no such proof is provided, the court finds in favor of the employee despite the document being signed. The same principle applies here. The claimant cannot rely solely on a signed instrument of transfer in the absence of any supporting evidence, such as bank records, receipts, some documents indicating a USD cash payment was made to the first defendant. The defendants will invite the court to consider the absence of such evidence material in assessing whether or not the payment was made. Then the claimant seeks to explain the absence of supporting document by characterizing the payment as a low-value transaction, assuming that low-value transactions are not documented. But virtually every company in the DIFC maintains a petty cash system and other traceable means of evidence. And in fact, the claimant provided evidence at page 444 of the new trial bundle, confirming a receipt issued for a low-value transaction. So when the company is already providing receipts for a low-value transaction, then definitely if she has paid cash, she should have been provided a receipt. So it only sums up to something that she has not paid the cash, and that is why the receipt was not provided. On the revocation of shares, the shares in question were formally issued. We are not denying that. But the claimant failed to pay the required consideration. In such circumstances, defendants were entitled under both the Article of Association to revoke the shares. It would be illogical and legally imprudent for the defendants to revoke the shares that has been paid for, thereby exposing themselves to the liability. More rational reference is that the defendants acted because they had not received the payment for almost 6 months. Even to date, she has not paid for it. Further, the claimant's contention set out in paragraph 35 on page 8 of the bundle. This is very important, that she was not afforded 14 days notice to rectify non-payment. This point is very relevant. The very assertion that such notice should have been given it itself is an admission that the shares were not paid for, contrary to the claimant's express position in the witness statement, where she maintains that she made the payment on 23rd January or 30th January. The fact is that when she is saying that she was not afforded the notice to rectify the non-payment is an admission that she did not pay. The claimant also contends that she was treated as a shareholder for 4 months without providing evidence of attending shareholders' meeting, appointment of directors. Even marketing materials referring to claimants as a shareholder do not override the statutory requirement that payment must be made for the share to get ownership of the shares. The assumption of ownership is not equivalent to lawful transfer. The timing of the revocation following the claimant's attempt to sell the shares to a third party does not establish a retaliatory intent. Rather, it is equally plausible, indeed more likely, that the defendants only became aware of the payment issue when the claimant sought to sell the shares without offering preemptive rights to the defendants in accordance with the articles and the law. Lastly, Your Honor, the defendants submit that they acted lawfully within their rights under Article 37, the shares of the private 37(1) of the DLC company law. Shares in private company must be allotted for cash consideration unless otherwise provided. The Articles of Association, particularly Clause 10A, says that the company has a lien over every share that is not fully paid for all amounts payable to the company, whether payable or not, in respect of the share. There is no requirement under Article 10 to provide notice of lien for up to 14 days. The clause in Clause D in Article 10 states that the company may sell shares under lien if the unpaid amount is not settled within, not up to, but within 14 days of demanding notice. This evidentiary burden and rests squarely on the claimant to prove that the consideration was paid. The claimant asserts that she paid this money, but offers no independent evidence of this payment. No bank transfer, no receipts, no accounting entry. Upon the failure to pay, the company passed a board resolution revoking the shares, which is annexed at page 119. So to conclude, Your Honor, the defendants submit that there is no credible or reliable evidence for any payment for the 10,000 shares. The defendant acted within their rights to revoke the shares due to non-payment. The claimant's story has shifted and her evidence is self-serving, and her reliance on conflicted witness renders her position untenable. The defendant requests the court that the court should order that the claimant did not pay the money for the shares. The shares that were revoked were valid and lawful, and the allegations are unsubstantiated. Thank you, Your Honor.
Ms. Khan, thank you. I have a couple of questions. The first is that you said that the alleged non-payment for the shares by the claimant only came to light after the claimant sought to sell her shares, and it seemed to be suggested that there was some connection between her seeking to sell the shares and it coming to light that the payment had not been made. And I'm mindful of the fact that the transfer of the shares to the claimant was made on the 7th of January 2024. That does not appear to be disputed. So could you explain to me what the connection is between the claimant seeking to sell her shares and this coming to light at early June, and it only coming to light then, almost 6 months after the shares were transferred to the claimant, why this alleged non-payment just came to light?
Okay, and Your Honor, the thing is that yes, the share transfer, there is a document resolution dated January, and during this period, there was something that transpired within the company around April and May, such that she was terminated around May 2024, and before May, I think around 17, she tried to get hold of these documents. Until 17th April, you will see it in the evidence of the claimant, which I will address in the cross-examination, that until 17th April 2024, she had no document with her, no proof that she is a shareholder, not even the resolution. She managed to get hold of it through her relation with one of the secretary. And obviously, after the document was shared, Mr. Nicolay was informed about it, and Mr. Aleksei was informed about it. And then around May, she was terminated. And then she gets a message that she wants to sell her shares. So the fact is that Ms. Aleksei, the shares were not given because she's actually the shareholder. It had a different purpose. It was different. It was to promote her face as a marketing person, somebody important, to attract the crowd for the brand. So it was under an understanding that those shares, if had to be sold, should be given back to the company or offered first to the current shareholder. But nothing like that was done. She was selling it to another party. So in the WhatsApp communication, Mr. Nicolay said that I have come to know, it's around 3rd June, he said, I have come to know that you want to sell the shares and you haven't paid for it. And you will receive a notice for the payment. And she was sent a notice. And then when she didn't pay for it, or she didn't dispute it at that time, that's when he canceled the shares. And it's not something that you can hold the shares in trust also. So he just wanted to ensure that it doesn't go out and it is secured until this thing is sorted out. That's it.
Thank you. Thank you for the explanation. I understand that if you wish to rely on the points that you have raised, you would be seeking to establish them in evidence. Is that correct?
Yes.
And sorry, just one more question. I think I may have misspoken. I said that the shares were transferred on the 7th of January. I just want to make sure that I have the chronology clear. The resolution to transfer the shares was made on the 7th of January. What date was the DIFC public register updated with the claimant as a shareholder?
Your Excellency,
I'm
I have
aware of
not
the
been-
claimant's case on this, but I want to just hear from the defendants. Thank you.
In my records, what I have been provided is only the resolution and this instrument of transfer. I believe it was kept on hold and nothing was done. But there is also one evidence where the license mentioned that on some day in the month of June, the claimant was removed as a shareholder. So the date when the actual documents were submitted to the DIFC portal, I am not aware of it. And
I understand. I understand. And Ms. Marnie, I understand you might be about to say that in the claimant's witness statement, she says it was done after the 30th or on the 30th. I'm trying to remember. Is that correct?
We believe it was done on the same date as on the 30th. This was some of the evidence that we requested disclosure for. That's why we wanted access to the portal to be able to see exactly what date those shares were registered, you know, physically going in and putting in the information. But either way, even if it was put in, the information was put in, let's say on the 1st of February, the date of the transfer of the shares in the DIFC portal, we believe, was on the 30th of January, because you can just insert a date that you say that the transfer was made, even though it may have been a couple of days after, but we're not privy to that evidence as we were able to. I understand.
But I mean, perhaps the exact date would not be relevant. I understand the claimant's position is that when she checked in July who the shareholders were, she was a former shareholder rather than current. Is that correct?
That's right, Your Honour. There is a record of her being a former shareholder, but she didn't take evidence of her being a shareholder because at that time there was no need. It was all on trust and it was there on the public register. She now has no access to it, so she cannot obtain that.
I understand. Thank you. And so a final question for you, Ms. Khan, just so I'm clear. I understand the defendant's position to be that the instrument of transfer dated the 30th of January is not a receipt and is not conclusive evidence of payment. And I understand your point on this and your analogy with immigration matters before the courts. I understand that. But may I just confirm, the defendant's view is the instrument of transfer is not a forged document. I just want to make sure I'm clear. What is your position on the validity of that document as not a proof of payment, but as an instrument of transfer?
This document has not been disputed or brought to my attention as something which is not theirs, but only the hands that reached out to her. And because she didn't have a copy of any of those, she obtained it through her relation with the secretary who was not authorized to issue that.
Right. So it's a valid document, but the defendants say it's not proof of payment having been made.
Absolutely.
I understand. Thank you.
Thank you.
Thank you very much, both of you. And I would just have a look at the trial timetable. I believe that it's now time to move on to the evidence of the claimant's witness.
Yes, Your Honour. I would like to call Anastasiia, the claimant, to go through her statement and give her evidence orally.
Right, there'll be an oath to be taken first, which the registry will administer, and I'll hand over to the registry for that to be done.
Yes, good morning, Your Honour. Thank you very much. Shall I start with position explaining, right?
Right, Ms. Denisova, first, as with all the witnesses, you will give an oath to swear that the evidence that you're going to give is going to be true, and then we will move into your witness evidence.
Okay, thank you very much.
Just a moment and someone will take you through the oath.
Sure.
Good morning, Ms. Anastasiia. Can I please confirm whether you'd prefer to swear on oath or by affirming?
I'm sorry, I didn't get you. Can you repeat?
Yes, of
Do you want
course.
to explain the difference? Sorry to interrupt you, Lena, and perhaps I misspoke as well by referring to an oath, but of course you're absolutely right that there is a choice. Could I trouble you to just explain the difference, please, to the witness? Thank you.
Yes, of course. So if you are swearing on oath, then you will need a holy book with you, whether that is the Holy Quran or the Holy Bible. So you will be swearing on oath. If you are affirming, then you are just affirming that you will say nothing but the truth, and you will not be putting your hand on any holy book.
Okay, first option.
So you would like to swear on oath?
Yes, let's do that.
Do you have a holy book with you?
Let me check. Yes.
Thank you. Can you please just show the camera that you're putting your hand on the holy book? Thank you so much. Can you please confirm your name and occupation for the court's record?
Yes, I'm Anastasiia Denisova, entrepreneur.
Please repeat after me. I swear by the Almighty God.
I swear by
The Almighty God.
Almighty God.
That I will say nothing.
That I will say nothing.
But the truth.
But the truth.
Thank you, Your Honor.
Thank you. And we'll now turn to Ms. Marnie just to confirm the witness's evidence in chief as her witness statement, and then we'll move on to cross-examination.
Yes, Your Honour. The witness statement of Anastasiia Denisova, dated the 28th of March 2025, is her evidence in chief.
Right, I think it's usual we would take her screen share a copy of the witness statement and her signature and confirm that it's her witness statement and her signature, please. Thank you.
So it is. Your Honour, is the screen being shared now?
Yes.
It is. Anastasiia, are you able to see the screen?
Yes, I'm able to see the screen now. You're in the portal.
Okay. Can you just please confirm that the statement at page 430 under section 18 is your statement?
Could you show us the page, please, Ms. Marnie?
Yes, Your Honour.
I think each document you want to take us through would be very helpful if you could find all we see at the moment is the portal, not any specific document.
Right, okay. So,
and don't worry, take your time. And I know it's difficult to search for page numbers and it can be a bit fiddly. We'll wait for you.
Thank you, Your Honour. It's my first time using this system.
No problem, we will bear with you.
Thank you. Are you, Anastasiia, are you able to see the witness statement at page 428 in the red number?
Unfortunately, no. Maybe you need to switch the window, just my recommendation. The window that you're sharing with us now, because we see only the register.
Right. Yes, Ms. Marnie, I think you may have shared the portal screen rather than the screen on which you're showing the specific documents within the trial bundle.
No problem, Your Honour. I'm going to stop sharing and then try to attach the right screen.
Yes, when you press start sharing, it should give you an option of which window to choose. And if you need assistance, by all means, take assistance. As I said, we're very happy to bear with you.
Thank you. I am taking assistance.
Yes.
There we go.
Yeah, now we can.
Right, okay. So Anastasiia, this statement, I'm just going to go to the beginning of it. On page 430 in red. And if I just scroll down a little bit to your signature. On page 435. Is this your statement and is that your signature?
Yes, it belongs to me.
Can you confirm that everything you've said in that statement is true and accurate?
Yes, it's true and accurate.
Your Honour, do I have permission for Anastasiia to go through her statement?
Is that going to be necessary, Ms. Marnie? I've read the statement. I take it that it's now submitted as evidence in chief on the record, and I don't think it's necessary to go through the statement because it is taken now as submitted as her evidence.
Yes, Your Honour, I feel that Anastasiia would like to clarify some points in there, if that is possible, if we have permission.
That is fine. I am also mindful that there may be points that, and I'm not suggesting this, but it is possible that there are points that need to be responded to from the defendant's witness statement submitted after Ms. Denisova's statement. So you have some leeway to ask some questions in chief.
Okay, thank you, Your Honour. Anastasiia, would you like to just set out a short background of your relationship, because this is something that the defence has brought up in their opening submissions. Would you like to just clarify how you met the first defendant and how the company came about, please?
Thank you very much, Your Honour, and Serena, Ms. Amani, for the opportunity to clarify my position. It won't take more than 2 minutes. As Ms. Han mentioned, that I was important person, and she mentioned that I was important person in the company. This is how I received my shares. I just want to clarify our story that beginning of the story was in early 2021. I first became involved with the defendant. We've been working each other in Moscow and Russia, and this is how I received shares as a chief marketing officer first time in Moscow, Russia. And I'm still existing shareholder and Russian shareholding company, which has been proven in my business statement with the copy from the registry. The process how I obtained the shares pretty much similar to the DFC procedure, but was more clear in Russia because I paid this nominal value for the shares in registry. I mean, directly to the registry. That's why I do have receipts, or I do have all the proofs needed. In June 2022, since we had like 2 years together in Russia as partners, we moved to Dubai to explore opportunities here, and this is how we moved as partners to Dubai. And coupled with the relocation, I was promoted to the chief executive officer to have for very important mission to do fundraising, to do strategic partnerships with real estate developers and banks, which confirmed by many first and second defendant publications, and especially publications of Mr. Galtcev in his LinkedIn, in his Telegram, and all of our chats. Then January 2023, since I was already existing shareholder in Russian entity, I asked Mr. Galtcev, or when can I receive for same shareholding status in our holding company in DFC. Since the company had amazing traction, we've been successful, and I asked him, and he told me that the legal counsel and Realist as a holding will assist me. How can I obtain my shares early January? In early January, we had an agreement, or a verbal agreement with him, that I need to pay $1,000. It's a kind of nominal value of the shares for my first 10,000 shares, which was 1% of the company at those dates. Then on 7th of January, I received a resolution, which was for me the sign, right, that we are going into the deal. On 23rd of January, it's very important to mention to the Ms. Han and to the defendants, I'm not shifting my position in both particulars of claim and witness statement. I mentioned that the deal was finalized and the receipt of payment was made on 30th of January, and I keep my position the same, but the actual transaction was made on 23rd of January after our meeting. Why I've done it? Because it was nominal money. We had a executive meeting in Trade Center and then came to the office. It was emotionally a huge race because we met one of the billionaires whom we dreamed to meet as a partners, and I decided to provide the money, and it was handed hand by hand in our one-on-one meeting. After that, on 30th of January, I was in the office and received from the secretary. The Ms. Han position was that secretary is not authorized person, but in fact, she handed all our let's say document processes in the company. That's why she was witness in our transfer of shares. I received transfer on shares, and since I wasn't a lawyer of the company, I wasn't experienced at all this process, DFC process of share acquisition. I just received this share transfer, which included date, the place for the signature, the condition of the deal that says that I did payment $1,000 in exchange of my shares. I consider this as a receipt because I just truly followed the guidance from my senior partner, my senior former partner, Mr. Galtcev, because we were friends, we were close to each other. As he wished, I needed to sign it. I just signed it, and I assume they sign it later and register my shares, which confirmed by public registry. We've been worked together in March 2024. We were handling together with existing shareholder Mr. Kuchin and Mr. Galtcev to Saudi Arabia. And in video, he confirmed that I'm the founding partner at Realist. I know that your honor weren't able to see the video, but it's okay. We can show it when it will be convenient time. One can confirm my status as a founding partner. And till also very important thing that in April 2024, it was the time when our first conflicts on the business purposes have been raised and started. I understood that I want to leave the company, and when I sold my shares in the end of May, it was the date of SPA dated 28th of May, and then on 3rd of June, Ms. Han just pointed out that the termination was provided by Realist, but it was first mutual termination, and we have all the proofs of that. And second, it was done on 3rd of June as my shares revocation, and first time mentioning that I'm not a shareholder anymore. That's also very important. It was on the one date when I asked early morning on 3rd of June, I asked defendants to transfer the shares according to our SPA. They have all the rights, transfer the shares from my side to the Nikola Kazutik. They rejected, sent me the notice that they will revoke my shares, and sent me the mutual termination, which been signed by my side and his side in one date, because he was angry that I'm going to have kind of financial profit from share status, and I wasn't able to sell, and blah blah blah. But yeah, because we are here not for the shares revocation, and primarily issue is do I've paid or not. That's why I just pointed out some key facts to show that our conclusion. I'm existing shareholder in Russian entity still, and I was the shareholder of Dubai entity. I didn't have any particular reason not to pay $1,000 since was considered as nominal value. Third, in our company structure, which I also pointed out in my witness statement, it was absolutely a normal thing to exchange cash. We received cash, we exchanged cash in the company. It was absolutely a normal practice for us. I was treated as a shareholder, and which confirmed by all marketing materials of the company, and the instrument of shares which I signed, I recognized as a receipt, because this document has all the conditions it's needed, and I followed clear procedure of the company legal counsel of the Mr. Aleksei Galtcev as a sole director and main shareholder at the company until 3rd of June. They have never sent me any notification that they have, or for example, they have any issue about my payment, or I need to sign some kind of additional document. No, it's haven't been done till they revoke my shares. Maybe that's it. If you do have any questions, Your Honor, legal counsel from both sides, please let me know. I'm here to answer all. Thank you.
Thank you very much indeed, Ms. Denisova. May I ask you, just going forward, because we have a transcript that will be made of today, if I could ask you to please just slow down a little to make sure that we all pick up your points. You will shortly be questioned by the defendant's counsel. I think it's quite important that we don't miss any of your evidence. So if you could slow down, that would be appreciated. Ms. Marni, that was quite a comprehensive clarification by Ms. Denisova of her witness statement. I presume there were no further clarificatory questions from you.
Your Honour, just one question, because as you say, Ms. Denisova was speaking very fast. Ms. Denisova, could you just clarify the date of your termination of employment and the date of the revocation of your shares? You say was the same date.
Yes, the date of mutual termination agreement provided by Magic Flash Realist, that was subsidiary company of Realist Holding, was 3rd of June. On 3rd of June, I received a notification that I will be removed and terminated as a shareholder, and revocation date was on 4th of June.
Okay, yes, Ms. Denisova. Just to clarify that you were notified of the revocation on the 4th of June, but in the evidence, you know, we have provided the actual notice for the revocation on the resolution was passed on the 3rd of June, and you were notified on the 4th of June. Okay, and you also gave notice of your share sale on the 3rd of June. So all these three things happened on the same day. Is that correct?
Yes, is that correct?
Thank you, Mr. Denisova. That's all, Your Honour.
Thank you very much, Ms. Marni. Okay, Ms. Denisova, you'll be asked some questions now by the defendant's lead counsel, Ms. Khan. Again, please answer slowly and clearly. Over to you, Ms. Khan.
Thank you. Thank you for your clarification, Ms. Denisova. We could have addressed this in the re-examination, which is a normal process, instead of... Anyway, just to make you feel comfortable, the questions will be very simple. You have to answer it in yes or no, and unless it mandates that you want to give explanation. But this is normally in cross-examination, you ask leading questions, which ends up in an answer with a yes or no. Okay. You filed your witness statement in support of your claim dated 16th April 2025, didn't you?
Can you repeat, please? I'm sorry.
You filed your witness statement on 16th April 2025, didn't you?
I filed my witness statement on another date, as I remember. I can check.
Okay, no problem. I just want to confirm that where are you currently based for your cross-examination?
Yes, the issue date of my witness statement was made
No.
on
Please answer the question right now. In which are you in the office or you're at home? Where are you?
Ms.
I'm-
Khan, I'm sorry to interrupt, but I think the witness was trying to answer your previous question. In
Okay.
fairness to her, she just was trying to look up the date of her witness statement. Let's give her a moment. And may I suggest, if you have facts that are completely non-controversial, such as dates of witness statements, etc., please feel free to just make that assumption and we can check it. But I just feel we'll get through the cross-examination much quicker. It is quite difficult doing cross-examination in the virtual setting, so we can perhaps stick to the questions that are necessary for you to for your cross-examination. So let's give the witness an opportunity to answer that first question, and then let's move on to your second question about where the witness is. Ms. Denisova, you were, I think, going to answer the question about whether your witness statement was issued on the 16th of April, 2025.
Your Honor,
I have the date's wrong, actually. I think it's not the 16th of April from memory.
Actually, Your Honor is right in front of me, so there's no point disputing it's on 20th March. So no problem. The reason I asked the question is just to make her feel comfortable. You can't just start. It's very intimidating. Yeah.
I understand. Thank you for that, Ms. Khan.
Yes. Ms. Denisova, I just want to ask, where are you based right now for the witness statement?
I'm based at my home in Dubai.
Okay, and there is nobody in the room besides you?
No.
Okay.
I can only my two dogs.
Okay, and you don't have any communication through WhatsApp, any guidance on through WhatsApp on your screen? All right.
No.
Thank you. Thank you so much. Thank you for clarifying. I want to know that, do you hold a degree of formal education?
Can you repeat, please? What does it mean?
Do you have a formal educational qualification?
Yes, I do have Bachelor in Finance.
Okay. And have you previously set up a business entity in the DRC?
No, I haven't set up any business in DFC. I was promoted as a shareholder after 2 years of our setup.
Okay. And so you're not familiar with the legal requirements for transferring the shares under the DRC law, do you?
Now I'm quite familiar after I opened the case a year ago.
Okay, fine. Now let us turn to your involvement in the company where you asserted your position. You were never appointed as a director of Real Estate Holding Limited, were you?
I had appointment, verbal and real appointment, not the confirmed by the document, as a CEO at Middle East for Realist, but we didn't have specific entity for that. Means I had real obligations, kind of not obligations, real responsibility to be the CEO, to be the face of the company, but I didn't sign any official document to be appointed as a CEO.
Okay, so so I assume there is no board resolution also to appoint you as the CEO? Yes.
Can you repeat?
No?
Sorry.
There is no board resolution appointing you as a CEO?
No.
Is there? No. Okay, and you handle business development and public relation function, didn't you?
I did have fundraising responsibility, meaning attract investors, made strategic partnerships, and made public relationship. Yes.
Okay, and let us go to the timeline relating to the payment. You first stated that you made the payment for the shares in cash on 30th January 2024, didn't you?
No, I didn't. I've made my statement to confirm that the receipt of the receipt date is dated on 30th of January. But since when I opened the case against Realist Holding and Mr. Galtcev, the primarily issue for me, from my perspective, was revocation of shares. Since your owner decided to make primarily reissuer as a payment, in my witness statement, I clarified and specified the scenario and the dates and timeline, how we put it out and when I handed the cash. First, it was on 23rd of January, and then on 30th, I signed the document which was pre-populated by defendants. Thank you.
So let me understand that when you were presented with the evidence that Mr. Aleksei was not in the UAE, you corrected because on many occasions your counsel has mentioned 30th January. We have on your pleadings, even in your case memorandum, your counsel, obviously with your consent, has put that date as 30th January. But then the witness statement of the defense of the defendant, to be precise, provided evidence that Mr. Aleksei was not in the country on 23rd January 2023. So, sorry, 30th January 2023. So you corrected your statement, is that right?
Ms. Khan, again, I confirmed that the 30th of January was the date of receipt. Particulars of claim just behind me. On 30th of January 2024, the first defendant finalized the transfer of 10,000 shares to the claimant for $1,000, which claimant paid in cash, which we didn't specify the date when I paid. This is first. From my witness statement, I can also put you same thing. Just let me check. Yes, on the same day, I had one-on-one discussion with the first defendant and the office, during which I handed him $1,000 in physical cash as a payment for the shares. In both particulars and in each document, I mentioned that that's the 30th of January. That's the date of receipt. This is correct.
Okay. Now let us look at the exhibits which you have presented, in particular Exhibit AD7. If I could request the counsel to share the screen for this exhibit.
Certainly.
It's, I think, page 444 of the new bundle.
Is page 444 showing?
Yes.
Not for me. I've still got the signature page of Miss Denisova's witness statement, which is 435. So if you scroll down,
okay. When I'm referring to the numbers, it's the green one, because I believe the green one is the latest.
Confusion. Right. That's fine. So which page would you like us to look at?
This AD7, Exhibit AD7.
Did you say page 444?
No, not the red one, because the red one was the case management number.
Sorry, let me just stop for 1 second. Miss Moni, have you got the new, are you relying on the new bundle or the old bundle? This screen sharing that you're carrying out, is this the new bundle or the old bundle?
Your Honour, it's the new bundle that's on the court system that I logged into to assist the court today. I was originally relying on the old bundle, but we decided to stick with the new bundle, right?
Of course, but I think we discussed with Ms. Khan that if she wants to rely on the old bundle, it may be easier if she screen shares from her bundle, and I will find the relevant documents because I'm very familiar with the new bundle. So Ms. Khan, shall we proceed that way? It might be terribly frustrating. I'm assuming, and I haven't been focusing on the green numbers, but that they're not sequential because it's a different bundle. And it may be easier if you screen share the document, you or your colleagues screen share the documents that you wish to take the witness to. Will that work?
Your Excellency, I am also relying on the new bundle, but apparently my colleague didn't realize, or whatever it is, that there are two numbers which will confuse the court. But I did understand that the red one is from the case management, which was used. And that's why when it is filed again, the green one is the one which I will be referring to. And,
certainly, but if you're going to ask Ms. Moni to be bringing up the relevant documents, am I correct in understanding that in the new bundle, we will not have sequential numbers in green? Is that correct? Because that's going to get quite confusing in finding the relevant documents. I may have misunderstood, but I would assume that the new bundle and the old bundle are paginated differently.
I don't know on what basis the new bundle has reached around 1,477 pages. And again, there were a lot of repetitions of documents. But what I have done is that I have just pulled out the 62 pages with evidence of the witness statement so that I have a focused document to address. I can share my screen with the witness statement I have. And secondly, the court has not yet granted me access or transferred the case file to my account. So that is making it difficult for me to navigate through the portal. So I have the PDF files which I can share with the screen, with the court.
Right. Well, I'm sorry to hear about the trouble that you've been having. In relation to the documents you have in PDF, what numbers do they have on? Do they have the green numbering?
Same. And the red.
They have both. Why don't you screen share the documents you want to take us to? Absolutely. And I have no doubt we will be able to find the documents. And if we have any difficulty, then I'll let you know.
Sure, I'll do.
Thank you.
Thank you.
Now, do we need Miss Marnie to stop screen sharing?
Yes.
Yes. Good.
You can see it?
Yes.
Okay, fine.
Yes.
Ms. Denisova, you have not provided a receipt for the alleged cash payment, have you? Instead, you rely on Exhibit AD7?
I have provided a receipt for the payment, which are called instrument of transfer, and which conducts all necessary details of the deal. Since I was the shareholder, and other shareholders, as you could see them in the resolution, they had also shares obtaining process, right? And the receipt that you show, it's not relevant receipt to this matter. It's a receipt how the employee received salary in the company or been compensated as a bonus. For the shares payment thing, we just used to have instrument of transfer resolution, and that's it. We can confirm it if the company, if we need, we can ask the secretary and realist holding to prove that all shareholders have the same documents. Thank you.
You are not answering my question. I think I framed my question in such a way that you should end up answering in a yes or no, because every question if you have an opening statement is not going to get over. So my question is very simple, that your Exhibit AD7 at page, let me take you back again.
Okay.
It relates to payment of salary and it's not a share transaction, correct?
Yes.
Yes. And the recipient of this cash, Demian Sergeyevich, is an employee and not a shareholder, right?
I shown this document and I have all the rights to fully answer your question, not only yes or no. Please allow me. I put this document as an exhibit and as a receipt just to show that at Realist, as a company environment, was absolutely normal to have cash in the office, because usually all the employee of the company received salary, bonuses, made the compensation, got back money to the company through those receipts. Thank you.
Ms. Denisova, okay. I'm sorry to interrupt you. May I ask you, it would be helpful so that we can get through all the evidence today. I understand that you wish to explain your answers, but it would be helpful, if it's a yes or no question, if you could give your yes or no first, so that we have the answer on the record. And then if you would like to provide any further explanation, you may do so. But I think it will be helpful if Ms. Khan is able to get an answer to her questions. Thank you.
Thank you.
Okay, could you confirm this, the Mr. Damien, is he your husband?
He is my husband now, but he wasn't the husband on the date of receipt.
Okay, so it was easy for you to get hold of this document because he's your husband when you filed the case, yes or no?
Since I didn't, yes, since I didn't have documents from my side and all of my receipts been in the company, I didn't have them. I asked Damien to provide it to show to the court that the cash was the common practice in the company.
Absolutely. And for a cash, which is a common practice, as you stated, the company issued a signed receipt, yes or no?
Can you repeat, please? I'm sorry.
Or you just stated that the company provided accepted cash, and we can see that for the cash payment, the company has issued a receipt. So for a simple transaction like this, the company issues receipt, yes or no?
That's the example. No, for this is example of salary compensation, and we hadn't have any specific receipts instead of instrument of share for the shareholders. Since
No, you are confusing. I understand that you want to make your point. My question is totally different. This is a receipt issued for cash by the company, yes or no?
Excuse me, can you repeat?
This is a receipt issued by the company for cash received, yes or no?
It's yes. Yes, this document was issued by secretary.
Doesn't matter. But in your case, there was no receipt issued. Receipt like this for cash received.
The thing is that yes, I provided money to my boss. He should give me a receipt if it's common practice for the company, but he didn't. The company failed to give me the receipt. Yes, you're right.
Okay,
And
so
I
you were
had
not
only
issued a receipt, but
yes.
And there is no bank statement which proves that you have paid the 10,000 cash.
There is no bank
The $1,000, sorry, and
yes.
there is no exchange receipt because I believe you're discussing US dollars. So for US dollars, you need to convert the money into dirhams from dirhams to USD. So you have any exchange receipt for the dollars?
You asked two questions. Let me answer first and then second, okay?
Sorry to interrupt, Ms. Conn. If you could just ask one question. I think that was two questions. There's no bank transfer.
No, my question was very simple, that if you are going to pay cash, US dollar, do you have an exchange receipt?
Let me answer your first question about bank records, if you allow me, and then I will answer your second question about exchange receipt. For the bank statement, no, I didn't have it, and I don't have it because the transaction was handed in cash. Yes, the transaction was in US dollars. Third, no, I don't have any exchange receipts since the fund that I've been using my fund when I relocated from Russia to Dubai in 2022. I had my money in US dollars since it was only the currency which was acceptable in Russia to change rubles to dollars. In the currency this was acceptable in Dubai. I handed them in my storage at my home, and I took it and provided it to the boss. And yes, he didn't give me any receipt for that instead of instrument of transfer, and I just simply followed his instructions.
Okay. And when you made the payment, was there any witness?
No, because it was one meeting in the office meeting room.
Okay. And the meeting room does it have closed doors, or it has windows, is transparent, or you cannot see through?
I'm not an expert, but I just can say yes, the meeting room has the door and has the window.
No, I mean to say anybody could see that you made payment to with cash. I mean, you made cash payment to Mr. Aleksei.
I didn't see any people around us this time on meeting room.
Fine. So let us now consider your next point on the instrument of transfer. I will take you to the page 442 of the bundle.
Okay.
So 442, I'll just reduce the size a bit so that you can see the whole page. All right. Now the instrument of transfer which is found is the document you rely your support for this share acquisition, right?
Yes.
Okay. Does the document does not confirm that you actually paid cash?
Yes, this is the receipt.
No, it's an instrument of transfer. A receipt is totally different. This is an instrument of transfer, and this is a standard line where you have to mention the consideration, but there is no proof that you actually paid cash, does it?
There is a proof, and no, I don't agree with the document clearly states provided to me, which states that condition of the money acquisition, right, and the cash, and this is a receipt and transfer, and in legal practice it could be both documents.
Okay, fine. We will leave that for it's your version, but it's normally when you do a share transfer, you have to write the good and valuable consideration of the money provided to me. But it's not a receipt, it's an instrument of transfer.
Ms. Han, in this case, this is company responsibility to provide me fully guidance what I need to fulfill. As a shareholder and as an employer, I just received the guidance that I need to sign this instrument of transfer after the payment, and no other instructions I have never been given. And you, as a defendant's representative, haven't provided any documents to support your words. Thank you.
Okay, but did you ask for a receipt?
I didn't ask because simply instrument of transfer concludes all the condition of the deal, and then I received the shares and the registry after that. I mean, but I didn't need it. I saw myself in registry, and for me it was a legal basis that I'm the legitimate shareholder. And even when I opened the discussion with Nicola to sell my shares, he checked the registry and he was satisfied that I'm in the registry for quite long time, yes, for almost half year. That means something, right?
We will come to this later. The question is that you allege that this is a receipt for the cash you received, but did you have a copy immediately after you made the payment?
No, I made the payment on 23rd of Jan, and on 30th of January, I received the pre-populated document to sign in from Jamal, as actually she is the witness and the same instrument of transfer.
Okay. Now, regarding the alleged payment, which confirms as a shareholder, you claim to be a shareholder, right? Did you receive any dividends?
No, I didn't, because the company as a startup, it's not the dividend business model. This is the model when we attract more money to raise the company valuation, and it wasn't the part of the articles of association. And no, any shareholder received any dividends.
Okay. Did you receive any notices, shareholders' notices?
Yes, for sure. I received when I was registered, I signed the document. This copy was...
No. Notice for meetings. Shareholders meet, right?
No,
did you receive any notice for meeting?
Yes, because no, I didn't receive, as the no meetings were arranged this time.
That is different. There were meetings, but you didn't receive the notice. Regarding any board communication, did you receive any communications, board communications?
No.
Okay, you had no share certificate?
I'm sorry?
Did you have a share certificate?
No, I didn't have it because I saw myself in the registry and I wasn't planning to use it somehow. That's why I didn't ask the company to provide me share certificate. I just simply asked in April to provide me all these documents from Jamal, as she was the witness and official secretary. I mean, actual secretary, yes, she's on the screen.
Okay, if I could take you to this page, your Exhibit 88.
I'm sorry to interrupt you. And also very important thing that it's not my failure that I wasn't invited to the meetings. It's the company, corporate governance thing. It's not my responsibility to be invited. It was my right. Thank you.
Okay, and it was, you're right. And if I could take you to page 88, no, sorry, exhibit 88, which is at page 446. I believe that you did not follow up for a receipt or share certificate or even the transfer document until mid-April 2024, which is almost 4 months after you became the shareholder, right?
Yes, that's right, because I didn't plan to do anything with them. When I was planning to sell them, I asked the secretary to provide me all the legal basis behind my shares.
Okay, but if you see the screen and if you see this text, the pictures with a hand, I believe that's your hand because the box is green, right? And if you see on this page, the second page, this document was provided to you by the secretary, I believe on the same day in mid-April. So before that, you did not ask for a receipt, right?
Yes, as I
No
told you,
document.
I didn't need it.
Okay. So is it possible that these documents was not released to you as you did not pay for the shares?
I don't think so. I mean, I'm not a company counsel and company lawyer. I paid for the shares, and when I needed these proofs, I asked for them. But since I was active employee, it was pretty much busy. The shares were registered, and for me, it was the best. The best sign from the company that I'm existing shareholder. When I needed this, I asked the proofs. From the secretary, if the shares weren't paid, why defendants were registered this?
So do
Can
you
you
normally ask for proof after 4 months for anything you buy also?
normally for whom? I mean, I was
Anything
employee,
you
but
buy, you ask for the receipt after 4 months?
I had received, I had instrument of shares, and
No,
when I did
this
this,
you received after 4 months. This is after 4 months, not immediately when you allegedly paid for it, right?
Ms. Han, what are you talking about? Is more kind of, yes, psychological session. We had very trust relationship, and I trust to this person, I mean, Mr. Galtcev, that he duly registered my shares, and I'm legitimate shareholder. Whenever I open the discussion with buyer of my shares, I ask for that because I had a reason for that. But before, I had no reason to ask this. Yes, because we trust each other. I worked in the company a lot of time. I didn't need it. Thank you.
I think I have a wrong reference of the bundle. Just 1 minute.
And also very important that there were no any dispute on my shareholding and status and my ownership till 3rd of June. That's why I mean, typically, psychologically, didn't even think about it.
Okay, if I could take you to page 464 of your exhibit, which I believe is exhibit AD12. Here you are discussing, it's your telegram message with Mr. Aleksei,
It's not my
right?
message, it's his messages to me. Yes.
Okay, his message. In this message, if I could read it out, you have been denied share registration of the shares due to the fact that you have not paid for your shares. You will receive the corresponding letter today by email, dated email, and then come to the office and provide the payment made before 3rd June. So I believe that I think there is something deleted because the message is not connected. So here, I believe there should be a conversation which says that you are saying that you made the payment, but here, Mr. Aleksei is writing to you, come to the office and provide payment made before 3rd June for the shares. So far, Holding has refused to register the transaction and has initiated the return of your shares due to your non-payment. So my simple question is, when you were confronted with a claim that no payment had been made, I don't see any rebuttal in this message.
First of all, Ms. Han, very important to mention that transaction was registered in the FC registry. The shares revocation will happen on 3rd of June and post
No, we are not denying that. We are not denying that. The focus of this hearing is whether or not you made the payment. Simple. So the question is that when Mr. Aleksei told you that you have not made the payment, or if you have made the payment before 3rd of June, because this is 4th of June, come with the proof. So did you respond with a rebuttal?
No, because I was shocked.
No further question.
Please, can I make more comments? I'm not finished. I'm sorry. No, I was shocked. That's why I didn't reply, because my shares were revoked, and I felt myself disaster because my closest partner and my friend just took my shares. Do you know what is the feeling about?
This is at 5 o'clock in the morning. I don't believe your shares were taken at on June 4th at 5 o'clock in the morning. Or at 10:30 a.m. I don't think so.
They were taken on 3rd of June. I received that message. And according to the company articles, if they had any issue with the payment, they needed to give me and grant me 14 days.
No, it is within 14 days. Within
14 days. But de facto, my shares were taken. Then I received this message early morning. I'm shocked. That's why I didn't answer, because I understood that I need to hire legal counsel. This is what I needed. And on 10th of June, we opened the case.
10th of June. But you had communication with the counsel. Anyway, so I will just end this with few questions. And you basically have not provided any receipt. When I say receipt, means not instrument of transfer, because that's an instrument of transfer, share transfer, which we are not disputing. So you have not provided any document to show who received the money and when and how. Nothing, right?
No, it's not right. I've provided full story and full documentation with sophisticated evidence that I've paid on 23rd of January, and on 30th of January we finalized the transaction, and my shares were registered. An instrument of transfer, this is your opinion that it's not received, but it's not true.
Okay, but when you receive this message on 4th of June, where Mr. Aleksei is asking you to come with the proof, did you go and meet him and show that, yes, this is the transfer instrument of transfer, this is the proof? Did you go and meet him to show him that proof if you think you have paid for the shares?
No, because I sent them the official message to prove my rights that I can sell the shares. They rejected. They took my shares, revoked my shares, terminated myself as a shareholder. And I was shocked when I received this message, and I understood that I don't want to continue this manipulation and conversation. And I opened the case because my shares were taken, and I lost a lot of money because of that. And he wasn't be able to provide me opportunity to transfer my shares to the Nikola. You know, the main purpose of that was to have myself, to be myself as a shareholder and provide, according to the articles of association, I had a rule, I had the rights to provide this to the Nikola, but they rejected this, and I understood that I have my losses. We had a settlement agreement with Nikola. That's why I opened the case and didn't answer this message, because my shares were already taken, and it was illegal to myself.
Anyway, we'll dispute. The question remains that there is no evidence of payment. That's it. It's very simple and plain. I have no further questions. Thank you.
Okay.
Thank you, Ms. Khan. Ms. Mani, do you have any questions in re-examination?
Yes, Your Honour. Ms. Denisova, could you just kindly explain the facts that led up to the termination and the sale of your shares? Can you just explain the sequence of events to the 3rd and the 4th of June? what action?
I'm so sorry to interrupt you, Ms. Marnie, but we're on a very limited time today. You're going to have to be more specific. We have a very detailed witness statement from Ms. Denisova, and we did have some helpful clarificatory evidence in chief this morning about the events that led to the 3rd or 4th of June. So that we are as efficient as we can possibly be with our time today, bearing in mind that we have 3 witnesses to go, could you please be specific about which specific events you are getting at? I presume there is evidence that you wish to bring out from Ms. Denisova that hasn't been covered already. And given what we've already heard and what's in the witness statement, being specific would be very helpful in terms of the time pressures that we're under.
Your Excellency, one more thing is that shouldn't the re-examination question be based on my cross? And I don't seem to remember asking this question.
Well, I assume, to give the benefit of the doubt to Ms. Marnie, that she is asking re-examination in relation to your cross-examination, but you're absolutely right. You need to be specific about the point that was raised in cross-examination that you are specifically redirecting the witness to. If you need a moment, that's fine, but we need very targeted, specific re-examination.
Okay, thank you, Your Honour. Okay, Ms. Denisova, were you given 14 days notice at any point in time for the fact that you were not, relating to the fact that you had not paid for these shares at any point in time from the date of the what we call the instrument and transfer, which is the 30th of January, between the 30th of January and let's say the 4th of June, at any time were you given notice by the company that your shares will not be transferred until you make the payment?
No, I haven't received any notice for that until 3rd of June.
Your Excellency, again, this is a new question which has not been raised in the cross.
Well, there's quite a lot covered in cross. I'm going to allow that for the moment. Do you have any further questions, Ms. Marnie?
No, Your Honour, that's all. Thank you.
Thank you very much indeed. Thank you very much for your evidence, Ms. Denisova. I do not have any questions for you, so you are free to stand down as a witness. Thank you.
Thank you very much.
Ms. Marnie, Ms. Khan, I see that it's now around 11 a.m. and we've been going for a couple of hours. I think it's a good idea for us now to take a break. I would recommend that we take a 15-minute break and resume, well, almost 15 minutes, and resume at 11:15. Ms. Khan, out of your 3 witnesses, could you please tell us the order of your witnesses?
The order of the witnesses, Mr. Aleksei will appear first and then the other 2 witnesses. And we are very happy to have the other 2 witnesses as hearsay because it does not address the issue in question, except for one which says that I haven't seen any, but it's like if the witness is saying that it was only 2 of us, so I don't see the point of a 3rd witness confirming a payment was made, or maybe perhaps you can cross-examine. We are fine with that. No,
certainly. I think what you're saying, Ms. Khan, is that Mr. Kuchin says that the claimant was issued shares but did not pay for the shares, which I assume is hearsay. And I think that what you're referring to in relation to the 2nd witness, Mr. Grigorev, is that he says as secretary of the 2nd defendant, following a review of internal documentation, I confirm that there is no evidence of payment. Is that what you're referring to in relation to the preliminary issue?
This witness should appear because it is if this is a secretary, then the secretary has a right to confirm that any receipt was issued.
I understand. I understand. Ms. Marnie, just in light of that, I do wonder whether you think it's going to be necessary to cross-examine Mr. Kuchin, the 3rd witness, given how limited his evidence is in relation to the preliminary issue, if you want to think about that, by all means, please do. But I think there is some merit in the point that Ms. Khan has raised as to the relevance of Mr. Kuchin to the preliminary issue.
Yes, Your Honour, but I'm still not quite sure. Are these two witnesses actually going to attend for me to cross-examine, or are they not going to attend? I'm not quite clear on that.
No, I think it was confirmed that all three witnesses are ready, willing and able to give evidence and to be cross-examined by you. And I think none of us dispute that the first defendant and Mr. Grigorev have evidence relevant to the preliminary issue, but the situation is more uncertain in relation to the third witness, Mr. Kuchin.
Yes, Your Honour. May I have some time to think about this?
Absolutely, that is fine. That is fine. Okay, so 11:05, we're going to resume at 11:20. We're taking a 15-minute break, and we will come back and hear the evidence of the first defendant. Thank you very much.
Thank you.
Ms. Moni, are you available now so that we can restart the hearing?
Yes, Your Honour, I am, yes.
Wonderful. Right, so we're moving on to the evidence of the first defendant, and I will ask the first defendant to please switch on his camera. And then I'm asking the registry, Lena from the registry, to please assist in administering the oath or affirmation to the first defendant. Thank you.
Your Honour, is the claimant supposed to attend the hearing for the cross-examination?
Well, I think the first defendant attended the hearing, the examination of the claimant.
Oh, I was
So
not
I think,
aware.
yeah.
Okay.
Good morning, Mr. Aleksei. Can I please confirm whether you would prefer to swear on oath or by affirming?
Sorry, please, could you please repeat the question because the sound is not clear?
Of course. Please, can I confirm whether you would prefer to swear on oath or by affirming?
Yes.
On oath or
On
by
oath.
affirming? On oath. Okay. Can I please confirm if you have a holy book with you?
What I have, sorry?
Can you please confirm if you have a holy book with you?
Yes.
Can you please show the camera?
I'm here.
Can you please show the camera the holy book?
Holy book, you mean like my ID?
No, so this could be the Holy Quran, it could be the Holy Bible. That is a holy book that you are swearing on.
Oh, I got it. I don't have it with me.
Okay, so can I please confirm if you would like to swear by affirming?
Yes.
Thank you. Can you please confirm your name and occupation?
My name is Aleksei Galtcev. My occupation, I'm in Dubai.
By occupation, what is your job title or what are you currently doing?
I'm founder and CEO of the company Realist.
Thank you. Please repeat after me. I affirm that I will say nothing
I affirm that I will say nothing
but the truth.
but the truth.
Thank you, Your Honor.
Thank you. Ms. Khan, if you would be so kind as to confirm the truth of the witness statement and Mr. Galtcev's signature.
I'm just trying to share the screen 1 minute. Mr. Aleksei, can you see the screen with the page bundle 583 in front of you?
No, it's just white screen. Oh yeah,
Okay.
now I see something.
You can see?
Yes, I can see.
Okay, just 1 minute. So could you state your name for the records, full name for the records?
My name is Aleksei Galtcev.
Okay, are you the first defendant in these proceedings?
Yes,
CFI 041-2024.
yes,
Have you prepared a witness statement in support of your defense in this matter?
yes,
Could I take you to this page 583 and the pages 583, just 1 minute. The pages 583 to 585 are your witness statements.
yes,
Could you confirm the signature at the page 584 belongs to you?
yes,
And do you confirm the attached evidence has been provided by you,
yes,
which pertains to witness statements of other witnesses?
right, yes,
And do you adopt your witness statement as your evidence in these proceedings?
yes,
And do you have any clarifications?
yes.
What is it?
Oh, qualifications, sorry, no.
No, clarification. Do you have to clarify anything related to your witness statement?
No.
Okay, fine. No further questions, Your Honor.
Thank you very much, Ms. Khan. Mr. Galtcev, am I pronouncing your last name correctly?
Right.
That's correct, Galtcev?
Galtcev.
Galtcev, okay, right. The claimant's lead counsel will now have some questions for you. And just like with the claimant's evidence we've just heard, it may be helpful if you indicate yes or no, and then if you would like to explain, you can do so after doing that.
I got it.
Thank you. With that, I will hand over to Ms. Marnie, who has some questions for you.
Thank you, Your Honour. I would just like to share my screen, or are we going to use this screen that we've already got?
I think it's better you share your own screen, Ms. Marnie, because we'll get through the documents much more quickly because you'll know where you're going.
Can I just check that everybody can see the resolution of the shareholders on dated the 7th of January? Yes. Okay, perfect. Thank you.
Your Excellency, I believe that the witness should be asked questions pertaining to the documents he shared and he provided to the court, and not the documents which were provided by the claimant.
I don't follow you, Ms. Khan. All the documents are in the trial bundle and are on the record. I'm not aware of any limitation on which documents.
Like AD4 is provided by the claimant, not by the witness. He can, if he has given a statement of claim, he has relied on any evidence, that's a different question. But these are the documents of the claimant.
But Ms. Khan, they're in the trial bundle. They're on the record. I'm not aware of any procedural limitation. If there's any provision in the rules that you want to take me to, under which the witness can't be asked about documents that he did not produce, then I'm happy to hear it. I'm not aware of any, but I'm very happy to give you a moment. But this is not a procedural rule that I'm aware of, that the witness can only be asked about documents that have been adduced by him as a party. But I'm happy to give you a moment, as you say. It's possible I'm mistaken.
Your Excellency, I'm not questioning your knowledge on this, but with my experience, I have come across a situation where I was also instructed that I should only ask questions pertaining to the document he shared. It is definitely an understandable fact that the hearing or the trial bundle will not be, the witness will not be able to, or could have, it is possible that he has not seen the whole trial bundle. So asking him questions, especially which is not submitted by him. I do remember in the rules it says any statement of documents which he has provided and any witness statement under the rules that he can be questioned upon, but not something which has been provided by the claimant. I would need a moment to refer to the rules and get back to you.
Of course. I mean, this is an important point. Why don't we, again, it's not something I'm aware of in my experience. In my experience, if the witness is not familiar with the document, the witness can say so. If the witness has something to answer on the document, then they can do so. But why don't we take a pause for a moment? And it's important that we get this right. Please do check the rules. I shall also, of course, check myself. We can pause for 10 minutes, but I have to inform the witness, Mr. Galtcev, you are now, you have sworn an affirmation and given your evidence. You are still under that sworn affirmation, even though we are pausing these proceedings. In that pause, please do not discuss your evidence with anybody, whether your legal team or anyone else, because you are still sworn in, and we will resume as soon as we can. Ms. Khan, is 10 minutes sufficient for you to look into this point that you wish to raise?
Absolutely. I will just come back to you immediately.
Right. I'll stay online. Yes, Ms. Mani.
If I may,
yes.
The difficulty here is that Mr. Galtcev has not provided a traditional witness statement for me to cross-examine on. He has attached 3 other people's witness statements that he's relying on. There's no facts in his statement. So it's very difficult for me to cross-examine him on what he has from his own knowledge. However, the documents that I was going to refer to are his documents, and they're not disputed in any way. For example, the resolution of the shareholders, for example, the instrument of transfer. These are all in their particulars as well, and these are all documents produced by him and his company. So there's no conflict about these documents.
Yes.
Otherwise, I am effectively prohibited from examining him because there is no material facts in his statement.
Yes, I understand. Ms. Moni, there's actually 2 issues here. One is the issue raised by Ms. Khan about the document, and the suggestion, Ms. Khan, I can't see, oh, now I can see you. The suggestion that the witness should only be asked about documents that he has deduced. That's one issue. The second issue is leaving aside specifically the documents, and I understand your point, Ms. Moni, on the documents, that actually these documents have been relied upon by the defendants. The second issue is, what can you ask a witness about? Now, in my legal tradition in England, you can actually ask the witness about anything that's relevant, even if it's not specifically addressed in the witness statement, if it's relevant to the issues at hand. But I would, we should be certain on what the position is. That's probably irrelevant for the moment, because I understand, Ms. Moni, what you're saying is you're going to ask about documents that have been relied upon by the defendants. All of these documents have been referred to, did you say, or relied upon? Just make sure I got that right.
Relied upon in their defence.
Okay, right. Okay. Ms. Khan, in case that's helpful for you, while you take a moment, may I suggest we come back at 11:45? If you need more time, we can take more time after that, but let's come back at 11:45.
Sure.
Thank you.
Your Honor, maybe I have to restart my system because it's really very slow.
Of course, we'll readmit you.
Okay, fine.
Thank you. Miss Marnie, do we have you back online?
Yes, Your Honour.
Wonderful, thank you. Ms. Khan, I'm glad you raised this point. It's given me an opportunity to double check the rules. And I've got rule 29.49 in front of me, which says, where a witness is called to give evidence at trial, he may be cross-examined on his witness statement, whether or not the statement or any part of it was referred to during the witness's evidence in chief, which suggests that the examination should be related to the witness statement. But at the same time, we have rule 29.49.2, which sets out the requirement under in the DIFC to apply the common law rule in Brown and Dunn. So a party must put to a witness its case insofar it is inconsistent with the witness's evidence, in order that the witness may have the opportunity to explain. Now, even if if the first defendant didn't deal with his case and his evidence, he does have a case, but it's set out in his pleadings before the court and the skeleton argument, etc. So there's what the rules say is that actually that's an important rule for procedural fairness, that the claimant's case should be put to him. Those are my preliminary thoughts, but please, I know you were also looking in the break at what the proper procedural approach may be. So I'm very happy to hear from you with your submissions on this.
Thank you, Your Honour. I have the rules before me. So when you said 29.492, I don't seem to have that. Then I went to the DFC portal and checked whether there is a 29.49. And it is not there. 492 is not there. There's just 29.49. Yes. And
yes, I should just clarify. And again, this may be my mistake. It's possible that the sub-paragraphs are actually only in the commentary. This is the commentary that I have, but the commentary is based on case law. So there is case law about the rule in Brown and Dunn, which I'm sure you'll be very familiar with, Ms. Khan, as a common law.
I have this
lawyer.
book too. I have the digital book too. Don't worry.
Oh right, is 29.49.2 not in the digital book? Okay. I've lost your face, Miss Khan. May I trouble you to adjust your camera? Oh, that's much better. That's much better. Thank you. Do you want to check the digital book? It's important that we get this right. There is no requirement that the case is put to the first defendant, and it's really out of fairness to him to give him an opportunity to respond. We've heard from you and in the submissions and the pleadings what his case is, what the cases of the defendants. But as we've got him as a witness, he must have an opportunity to respond, because there is obviously a dispute of fact between the claimant and the first defendant, and that's why we're here, or it relates to this specific issue.
True. Your Excellency, one point I am inclined to agree that yes, the documents provided, the witness statement provided were not the way it should have been. On the other hand, isn't it the claimant's case to prove the case? So you are depending on the defendant to prove your case. So that is something, which has to be considered. But I leave it to you. I do understand, but then it could go on for hours regarding the documents pertaining to the evidence provided by the claimant, which is a lot. So perhaps we could leave it restricted to a document which bears his signature.
I think the issue here is, I understand your point that the claimant bears the burden of proof in proving her case. I understand that. But I think the point under Brown and Dunn is slightly different. It's that the first defendant should have an opportunity to respond to the case that has been made against him. And I am mindful that there is a dispute of fact. I also take on board your point about timing, we do have limited time today. Ms. Moni, how long do you envisage your cross-examination taking? And can I just confirm again that you will be referring to documents that have been referred to in the defence and relied upon in the defence? Can you explain those 2 points to me? Respond on those two points.
Yes, Your Honour. I honestly won't take that long, not as long as my learned friend Ms. Khan has taken. I'll be very quick. It will just be quick points on the documents that they have relied on and the procedure that they followed.
And again, if you the basis of allowing you to cross-examine is based on the rules under which you would have a duty to put your case to the first defendant. Can you confirm that that is how your cross-examination is going to be conducted?
Yes, Your Honour. We're relying on RDC Rule 29.49. I understand Ms. Khan's point that the burden of proof is on us, but they are challenging our proofs, so we should be able to respond to those challenges.
Right. And timing, are you
Your
able
Excellency,
to say...
I just want to clarify one thing.
Just allow me to finish, Ms. Khan. I'm going to come back to you and give you an opportunity to respond. Let me just finish this point and then I will hear from you. Ms. Moni, in terms of timing and in response to Ms. Khan's point about timing, are we talking 15 minutes?
Yes, maybe less.
Maybe less. Thank you. Yes, Ms. Khan. And please take on board also, I understand your point about timing. We're talking about a limited cross-examination limited to 15 minutes, taking into account the duty under Brown and Dunn in Rule 29.49. And I'd like to hear from you on that and any other point you were just about to raise before I interrupted you.
No, Your Excellency, only I wanted to raise a small point, not that I'm cribbing, but the fact is that my cross-examination took long because the witness kept on talking.
That's no criticism, Ms. Khan. It's okay. We've got making good time today, and I'm not concerned about how long your cross-examination took, but I would like to hear from you. Now we've been told that there'll be a limited cross-examination of no more than 15 minutes. It'll be conducted in accordance with the rule in Brown and Dunn under RDC Rule 29.49. May we proceed in that manner?
Absolutely. And just one thing is that we have a language issue also with the witnesses.
Yes.
So perhaps you have to be very slow and simple English.
Yes, I think that's a good point. So I think we're all agreed about how to proceed. I have no doubt you'll agree, Ms. Moni, that we need to proceed slowly and clearly and stick to the critical questions. Now, on that basis, may I please ask Mr. Galtcev to switch his camera back on? Thank you. We are now going to continue with your cross-examination. Thank you for your patience and bearing with us. If you don't understand any of the questions, please do say so. I'm going to hand you over now to Ms. Moni for her questions.
Sure.
Hello, Mr. Galtcev, Serena, Mr. Mani for the claimant. I want to introduce you to this cross-examination gently because I understand there's a language barrier. Could you kindly just explain the role of Miss Anastasiia in your company, please?
She was responsible for PR and attracting new investors in the company. So she was responsible for all social medias in the company, my media and the company media. And she was the first touch point of new investors coming to the company.
Thank you. Can I refer you to page 440 of the bundle? Can you see the screen?
Yes, I see.
Yeah. This is this your...
I do not see the screen. I'm so sorry to interrupt you. Let me figure out what has gone wrong here. do not see. Ah, I do see the screen.
Yes.
Excuse me. Please continue, Ms. Moni.
Perfect. So, Mr. Galtcev, can you just explain, is this your LinkedIn account or your Facebook account? This social, it looks like a LinkedIn account. Could you please just explain how you have introduced Ms. Denisova in these messages, in these posts?
Yeah, it looks like my LinkedIn account, and this messages was made by not me, because all this was responsibility of Anastasiia. So she was a person who used my LinkedIn account and company account just to make some news, and she was responsible for PR and social media.
Okay, and did you raise any concerns about what she had posted using your official LinkedIn account?
Yes, I had some concerns about that. She was claiming that she's a founder. So the whole idea was about from her, like approximately 1.5 or 2 years ago. I don't remember exactly. So we wanted more attention from investors. And she come to me with an idea, so that she is going to be kind of nominal CEO of MENA, like a young girl who is going to be responsible for like a company in MENA region. And this is going to be like info news for like PR and media. And I said, okay, you can try to do this. And after she was claiming that she's a founder of the company, and myself and my previous co-founder told her that she can't do this, but she continued to do this, and it was kind of bad things.
Okay, so you did consent to her putting these posts on your social media for marketing purposes?
Frankly speaking, I'm not tracking what's happening with our social media. I'm focusing on the product and on the IT part. Yeah, but she was responsible for all social media.
Did you ask her to take these posts down?
Never. I have never seen it before.
Okay, no problem. I just want to now refer you to page 444 of the bundle. This is the resolution of shareholders.
Yeah, I see it.
Yes, so this is your signature and your document, right?
That's
Correct?
right. My signature.
Yes. On what basis were you wanting to or desiring to give Miss Anastasiia the 1,000 shares?
So like it was a team, like Anton Kargapolov, the developer, Dmitry Grigoryev have been working together for 5 years, maybe more. So he was responsible for like operations. Azamat, he's a developer. Anastasiia, she was a person who was responsible for PR, marketing, and social media. So she was a person, as I told you before, attracting like new investors. And Anton Baronov, he is my co-founder.
Okay, so you were happy with her performance and therefore you wanted to reward her or incentivize her to promote the company in a positive way.
So this was the whole team at that time. So literally all employees mentioned here. So it was like the whole team.
Okay, no problem. Okay, next page. Let's go to page 448. This is the instrument of transfer of shares. Actually, just before I go to that, did you attend a meeting with Ms. Denisova on the 23rd of January after the meeting with the billionaire investor? Do you recall this meeting?
No, we had a meeting with this gentleman on 23rd. I know about this gentleman, and after the meeting we were separate. As I remember, so, yeah.
Okay, where did that meeting take place?
With the gentleman that you mentioned.
Yes.
It was higher than DIFC. I don't remember how they call it, but it was in a cafe, not in DIFC, but the neighborhood after DIFC.
Okay. Okay, in some of the common areas within the DFC. Okay. So you're saying you don't recall having a one-to-one meeting with Anastasiia on the 23rd of January, but you were present in the DFC in Dubai on that day, and there was a meeting with a billionaire on that day.
Yeah, it was a meeting. We were together on this meeting, right? But after this, we had meetings.
No problem. Okay, so we'll go to this document, the instrument of transfer of shares. It's just a very basic document, not very complicated English on there. Can you just confirm that you signed this document?
So frankly speaking, the signature, it doesn't look like original signature, but I think I signed it. Yeah, but I think I signed it like online because at 30th of January, I wasn't in the office. I wasn't in the country.
Okay, so you would have signed it, if you signed it online, would there be like an email or an Adobe EchoSign link or confirmation that it was signed on such a day if it was signed electronically?
I'm not sure, but usually what I do, I print it. So I signed and just copy, write, and send maybe like in WhatsApp or Instagram. Or sorry.
So then there would be some sort of electronic date stamp to say it was signed on that date.
I'm not sure because I just like I killed my phone and I lost all the messages previously, but probably we can find it.
Okay, so you're saying that you signed the document on the 30th of January, not either before or after. It was actually on the 30th of January that you signed it.
Yes, so I suppose so.
Okay, and then what date would the witness have witnessed your signatures? How would she have applied her signature to witness your signature and Anastasia's signature?
The question is complicated. Could you please repeat it?
Sure. Do you know what date the witness signed this document?
I suppose so, the same day. So once I receive this type of documents, it's already signed.
Okay, but there is no evidence for the electronic transfer of this document because obviously you were in a different country, Anastasia's in a different country. We don't know where Ajmal was, but we assume, the three of you were not sat together at the same desk doing this. So there is no evidence. Do you have any evidence to say that this was done electronically?
Not with me. Maybe I should check.
Okay, thank you. Do you agree with the contents in this document? What you have signed, do you agree with what is written inside this document?
Not with all. So I never received the money.
Okay. Would you normally sign a document that you do not agree with?
So I suppose that the money will come.
Okay. So if we go to the paragraph that says, for good and valuable consideration of 1,000 in numbers and then in words, USD, provided to me by Anastasiia Denisova. Could you just explain what the words provided to me mean in this document?
I suppose that this is instrument of transfer of shares, just to put her on shareholder register. But I never think that this is a receipt.
Okay. Could you just explain why you signed a document that says that Anastasiia has provided to you $1,000? That's what it clearly says.
So like these typical documents that usually like lawyers send to me, I signed it with no thirds. And if they say me that I need to sign it, I just signed.
Okay, so you signed the document without reading what it said in there?
No, exactly. Once I sign this type of documents, like one-page documents, so I don't really think like I should understand all the things inside.
Did you understand that? Sorry. Did you understand that this was a legal document? Yeah,
for sure. So I understood that it's an instrument of transfer of shares. So it means that the Anastasiia will be registered.
Okay. And you understand that she needs to pay for those shares?
No, I was expecting that she was paying.
But in a normal transaction, when you buy and sell something, you expect a payment for giving the thing that you're selling.
So I really thought that she already paid to me, like on my bank account, but it never happened.
Okay, you felt that she'd already transferred the funds over to you by bank transfer.
Yeah, I thought it.
Okay. Just to confirm, your company is regulated by the DFSA? It's a financial services company?
No,
No?
it's technology company.
Okay, right. So as a CEO or founder of this company, you would ordinarily sign documents without reading them, just on the say-so of, let's say, for example, your secretary?
Now, if it's like a large document, like a contract, etc., I read it. If it's just like usual documents, I just signed it.
Okay. So you're telling me, are you saying that you did not read this one line, very simple document with only 4 or 5 lines that says, Anastasiia provided to you $1,000 US. You did not read that. You did not notice that. You did not understand the meaning of that, but you decided to sign.
No, I thought that the transfer has made to my bank account. So, and I signed it. But once I checked it, it wasn't.
Okay. Do you handle large volumes of cash or transactions within your business?
What does mean large?
Say, for example, you are receiving an investment from this billionaire that you went to meet. Would you check that he has made the transfer of payment, the transfer of funds into your account before you sign a document transferring him equity into your business, or would you just sign it on trust?
No, all money I usually receive, I receive or through the check or through the wire.
The wire. Okay. And your bank account is connected to your mobile, like on an app, so you can check very conveniently if the payment has been made?
Yes, it's on my mobile.
Okay. But in this case, you didn't check if the funds had been transferred to you before signing this document?
No, I didn't check.
Okay, no problem. So we've dealt with that. So I think on the 3rd of June, let me just find the page number for you. Was it, what page number was it? 3rd of June, Anastasiia contacted you to advise you of the share purchase agreement that she had signed with Nicola. Is that the case?
I suppose so. This date. Yeah, if you can share the screen share, I'm going to check the date.
Yeah, but I'm just trying to find the page. So number 5. It's just loading. Right, we're going to page 116. Apologies, this has taken me time to find this page number for your reference.
I think we're at 15 minutes. I'm not going to stop you. And I know it's taken a bit longer to find the documents that you want, but I just wanted to let you know that. And I mean, the dates here, I think, are not disputed.
Okay,
so for future questions, you can just say on this date, this happened, and then ask your question, because we could spend a lot of time trying to get the dates correct. And I think that's not important because I'm not disputed. Thanks.
Thank you, Your Honour. So on the 3rd of June, is it correct that Anastasia notified you of the share sale with Nicola?
Yes.
Okay. Is it correct that on the 3rd of June, you fired her from her position in an associated company of yours?
Fired? Sorry, say again.
You terminated her employment. You terminated her employment on the 3rd of June.
No, it was earlier, so I can explain.
Okay.
So I fired her on a verbal, like on a meeting, like a few months before. And I fired her because she was using like resources of a company for promoting herself and not promoting the company. So, and she was promoting herself as a CEO of a company and the founder of the company everywhere. So in different like newspapers. So I told her that this is not the case and she's not delivering the value to the company, and I fired her. But like Grigor, like what is his name, like on English, Grigor told me that in this case, if you fire her now, we should pay her like 3 times salaries, etc. So we should like buy kind of friendship just to cancel these relationships. That's why she was in the company 3 months more.
Okay, so you gave her notice earlier, and you allowed her to stay for 3 months on 3 months' notice.
Yeah, on on the respect that we work together like more than 2 years.
Is there any evidence of terminating her employment 3 months prior to the 3rd of June?
Yeah, but we need to bring more evidence about it. So I told to Grigor, I told to her, I told to Daria. So she was very close friends to her. And before I fired Anastasia, 2 weeks before, I told her that these 2 weeks she should work on the company very hard, because if not, I'm going to fire her. So
Okay.
she was.
So Anastasia was promoting herself with your consent, which you explained before, and she was in charge of PR, and she was promoting herself and the company. As you said, she was the face of the company?
No, she wasn't the face of the company. So she was the first point of speaking with new leads of investors.
Okay, no problem. So on the 3rd of June, you issued a resolution to cancel her shares. You rely on the Articles of Association of the company to cancel those shares because you say they were not paid for. Can you please confirm, under the articles, it says that you must give 14 days notice with your bank details, etc., where you want payment to be made. Can you please confirm on what date did you give that notice?
Your Honor, I should object to this line of questioning where you're asking legal question from a factual witness.
It's also a very long question, Ms. Marnie. There's a lot of background. I think we need to keep the questions short. The documents will speak for themselves. We have all the documents. If there's a specific document you want to take the witness to, fine. But I think the point made by Ms. Khan is well made. It's not relevant for the witness what the Articles of Association say. Let's ask the witnesses about facts and try and keep the question short so that the witness doesn't get lost.
Thank you, Your Honour. Mr. Galtcev, what date did you give Anastasia notice that she had not paid for her shares?
So she was aware that she didn't pay for shares, because once we issued the shares, everybody in the list was token by me that they should pay for the shares. And I have been waiting like for 5 or 6 months before this. And I understood that she didn't pay for shares at the moment she tried to transact it. And I spoke with this buyer. So he's a shareholder of one of the one of the companies in Realist. And he said that he was scammed because he was told like very different information about the company, what was real. And then I started to check, like, did she pay for the shares? And I realized that she didn't. And I told her, tell me, like, bring me the evidence that you paid, and your shares are going to be sent back.
Okay, so from the period of 30th of January to the 3rd or 4th of June, you assumed that the shares were paid for?
Yeah, I thought that it was a bank transfer, right?
And during this 4-month period, your accounting team didn't reconcile your bank statements with the company documents and receipts?
Please say again, I didn't get it.
So in the 4-month period between the 30th of January to the 3rd or 4th of June, let me rephrase the question. Does your company normally have monthly bank reconciliations?
Monthly what, sorry?
Do you reconcile your accounts? Do you have an accountant in your office? Somebody, a bookkeeper who keeps your records?
No, we have a company that keeps our books.
Okay, and they reconcile your statements, your bank statements on a monthly basis, which is normal practice?
They don't have access to my personal bank account.
Okay, right, okay. So
like,
to
I was expecting the payment to my personal bank account. It doesn't matter with the accountants or books of a company, right? So the whole journey, like this 5 months, I thought that the transaction was made to my bank account. So we never met about the payments, and no cash, as Anastasiia said, that was delivered. Never.
That's fine. So could you just explain to me, why would the company issue a receipt for cash if this was a payment into your personal bank account or a monies that were owed to you personally? Why would the company issue a receipt for this payment? It's not company money, it's your money.
I don't know. If I receive money, I issue the check, or I issue like my signature that I received it now, or okay. I received it on my bank account.
Okay, so your company would not ordinarily issue receipts for your personal receipts, money that is owed to you personally. The company would not ordinarily issue those receipts.
So yes, the company can issue receipts for my personal account.
So the receipt for cash would be from you personally, not from the company.
If I receive money for my like my money, I should write like a signature about that I received my money.
Okay, and you're saying that your signature in the instrument of transfer shares, which says this money was provided to you, is not a receipt for monies that is owed to you, not to the company.
It's transfer of the shares. Yes, it's not a receipt.
Okay. Okay. I think that explains everything that I need to present to the court. Thank you, Your Honour.
Thank you very much, Ms. Moni. Ms. Khan, do you have any questions in re-examination?
Sorry, I just have 2 questions I would like to ask in the re-examination. Let me just share the screen. Can you see the screen, please?
Yes.
Yes.
as I can see in this document, which was shared by the claimant's counsel, I believe you have transferred the shares to Anton, Dimitri, Azamat, Anastasia, Anton, right?
Yes.
Okay, and to do this, this is the first step. That is, you have, you have a resolution, and then the transfer documents come in the picture, right?
Yes.
Okay, now if I could take you to this page. Can you see this document 86?
Yes, I can.
Earlier I mentioned that you have transferred the shares to so many people mentioned in that document. So for all of them, whenever you do the transfer, do you sign this document?
Yes.
So can I safely assume that this document is treated as an instrument to transfer the shares and not as a receipt?
Ms.
Right.
Khan, that is a leading question. Re-examination is supposed to be
Okay.
open questions. Could you please rephrase your question? Thank you.
Okay. So could you tell me the steps that when you passed a resolution and for every transfer, what type of documents do you use?
So you use SPA after you receive money and after you sign transfer.
Mm-hmm. So is it possible that you sign this document before receiving the money?
So if I expecting the money or I thought it's transferred, yes.
Okay, fine. One question is that you were asked about checking the funds in your account. Would you check your mobile phone for payment received, which is supposed to be a cash payment?
Yes.
No, I understand. Yes, you. My question is, if suppose somebody gives you cash, would that transaction appear in your bank SMS?
If somebody gives me the cash, it's not going to be in the bank SMS, but I can place this cash in a bank account. Maybe this is your question.
Okay. No further questions.
Thank you, Ms. Khan. I just have a couple of questions for you, Mr. Galtcev. The first is, I don't think it's a material question, but you were taken to a WhatsApp exchange between yourself and Ms. Denisova after she's informed you of her sale agreement with Mr. Nicola after you found out. I think we just discussed that when you were being asked questions by Ms. Moni. I just want to take to the document. I think you were asked on the basis it was the 3rd of June, but it looks like the 1st of June. And I just want to make sure that we're not making a mistake. Thank you. Somebody pulled up that document. It looks like the 1st of June to me. I just want to make sure that we're not proceeding under any mistakes. Does that accord with your recollection? Could you make it a bit bigger, please? I don't know who's sharing at the moment.
Yes, I am sharing.
Yes, Miss Moni, you wanted to say something?
Your Honor, Ms. Denisova sent a formal email on the 3rd of June to formally record the transaction.
Right.
But I believe there was a conversation that was leading up to the days before. That's why I was going to ask Ms. Denisova in her cross-examination, re-examination about the days, the facts that led up to the 3rd and 4th. But it's on the record.
Nothing turns on this. Nothing turns on this. I just want to make sure we're not all at cross purposes. So there was a WhatsApp exchange on the 1st, and then a formal letter on the 3rd. Is that correct?
Correct.
Mr. Galtcev, I think we've clarified the position, but if there's anything you want to say about it, please feel free to do so.
Yes, please give me time.
I think that the question was just to confirm that this exchange took place on the 1st of June. And if we scroll up a little bit, I think the date is there, Ms. Khan.
Yeah,
Yes.
So I remember this exchange of messages. I met Mr. Nicola at the party, and he said that he just bought shares from Anastasiia. And I told him that she is fired, and I asked him, what did she say about the company? Because she knew that the deals in the company went south very bad. So we had a lot of loans, etc., and she knew about it, and she was firing out of the company. And I understood that she misled him, and I told her that this is not polite to tell the truth to our shareholder, to tell the false information about the company to our shareholders, and that I'm going to meet him. But at that day, I was flying like to Madrid, I remember. And we had a conversation about it. And I told her that she kind of making fraud with him. And after I started to check transactions, because I just understood that she's selling shares to our shareholder and misleading him about the situation of the company because she wants to escape out of the company and make money for this.
I understand. Thank you. And just a final question, Ms. Khan, can I trouble you, since we've got your screen being shared, to go to page 422 of the new bundle? I don't know which bundle you might be on. Oh, you're on the old bundle. I don't know what the reference.
No.
I do. I can find it for you. 1 second. It's 416 in the new bundle.
This is the new bundle. 1 second.
Oh, that's confusing. Okay, so it's 422 on the new bundle.
No, this is mine. 1 second.
Otherwise, I can share. I have it open, actually.
Okay.
Why don't I try and do that? Right, if you stop sharing, I will try and share.
Okay.
Just give me a moment. Sorry. Sorry, I'm having technical problems. Just please give me a moment. I should be able to get this back. A moment. Right. Can you see this document?
Yes.
Everybody see this document?
Yes, I can.
Mr. Galtcev, you say on the 4th of June, you say, so, yes, in your second message on the 4th of June, you say, so far, the holding has refused to register the transaction. Could you explain what you mean by that?
I mean that I understood that the shares weren't paid. I sent the message to the holding company that shares weren't paid and asked to receive my shares back before it's paid. So, and I mentioned to Anastasiia that she can come to me and show me the transaction that happened because I didn't find it.
Right.
And
so you say the holding has refused to register the transaction, and that gives the impression that the share transfer had not been registered, but I had understood it had already been registered at that stage. Is that correct?
I hope I understand the question right, but I knew about the transaction is happening. So
Yes.
about the SPA, I knew that the shareholder was misled and scammed. So I checked.
I'm so sorry to interrupt you, Mr. Galtcev. I'm not talking about the transaction of the potential sale of the shares. I understood that you were saying that this refers to the transaction of Miss Denisova's shares. I understood that's what you just said. Is that correct?
Yeah, so it was about the transaction from Anastasiia to new shareholder, right?
Oh.
So from Anastasiia to Mr. like Nicola.
Right, you're saying, when it says when you say the holding has refused to register the transaction, you're talking about the transaction, the new share transaction between Ms. Denisova and Mr. Nicola. Is that what you're saying?
Once again, so this is a question about holding refused transaction of shares to Nicola.
Right, okay. Thank you. That's very helpful. Ms. Khan, you want to say something?
I just want to say that we should confirm all the WhatsApp messages, whether it was originally in which language, because this is, if it is translated through AI, then we have an issue confirming the authenticity of the translation also.
But shouldn't that have been done before? I mean, we've already got it all in the trial bundle, and I don't understand that anybody has objected to the translations. You're absolutely right. One may have objections to translations, but I think those objections should have been made some time ago.
Unfortunately, I was not there.
Yes. In any event, I don't think anything turns on this. I was just curious because I didn't understand it. I don't have any more questions. Thank you very much for your evidence, Mr. Galtcev. You may now stand down as a witness. So thank you. It's now 12:30 p.m. and I'm very conscious of the fact that it's lunchtime, probably for all of you, if you're in the UAE at the moment. So I suggest that we take a 1-hour break for lunch and then we will come back now. Ms. Moni, have you had any further thoughts on whether it's necessary to hear from Mr. Kuchin?
Yes, Your Honour, I do have a couple of questions for him. I won't take long at all.
Fine. Okay, so we'll come back. We'll have Mr. Grigorov's evidence and then Mr. Kuchin's evidence, and then we'll have closing submission. So why don't we take an hour for lunch and let's come back at 1:35 p.m.
Thank you, Your Honour.
Thank you. Thank you very much, all of you.
Thank you.
Are we ready to reconvene the hearing, Ms. Moni?
Yes, Your Honour.
Wonderful, thank you. So I understand Ms. Khan will be having the defendant's second witness, Mr. Grigoryev, if I'm not mistaken. He appears on my screen as Dimitri. Mr. Dimitri, would you be so kind as to turn your camera on, please?
Hello.
Hello. Now, I'm going to ask the registry to swear you in so that you can give your evidence. And the registry will explain to you that you can either swear by oath or affirmation. They will explain to you what the difference is. Then you will proceed to be sworn in. to give your evidence. And I will hand you over now to Lena from the registry.
Thank you, Your Honor. Can I please confirm if you would like to swear in by oath or by affirming, or if you would like the registry to explain the difference between the two?
Can you repeat, please? My English is not good.
Of course. Can I please confirm whether you have decided to swear by oath or by affirming? Or if you would like the registry to tell you what the difference is between the two.
Between of what? Can you repeat?
Yes.
Would you be so kind? I think if you could explain what the two options are, then we can ask Mr. Dimitri which option he prefers. Thank you.
Perfect. So if you swear in on oath, you will be swearing in on a holy book of your choice. If you are swearing by affirmation, you will be affirming that you will be saying nothing but the truth without the holy book.
Yes.
Can I confirm that it is by affirming?
Yes.
Thank you. Can you please confirm your name and occupation for the court's record?
Dmitry Grigoriev.
And your occupation, please. So your job title?
I am COO of our company.
Please repeat after me. I affirm that I will say
I affirm that I will say
nothing but the truth.
nothing but the truth.
Thank you, Your Honor.
Thank you. Ms. Khan, do you want to just briefly ask the witness to confirm that their witness statement is true for the record?
Sure, I will just share the screen first.
Thank you.
Good afternoon. Could you please state your full name for the record?
Dmitry Grigoriev. Dmitry Grigoriev.
Are you giving evidence on behalf of the defendants in these proceedings CFI 041-2024? Are you giving...
Can you repeat?
Are you giving evidence on behalf of the defendants in these proceedings?
Yes.
Okay. Have you prepared this witness statement in front of you in support of the defendant's case?
I have written the statement in Russian and had it transferred into English. My English is not good.
Okay. But do you confirm the contents of this translated witness statement?
Yes.
Okay. Do pages, you can see at the top 591 in red font, and the pages 592 contain your complete witness statement?
Yes, I see it.
Okay. Do you confirm the contents are true to the best? I cannot see you, Mr. Dimitri.
Sorry, I'm here.
Yes. So do you confirm the contents of the statement are true to the best of your knowledge and brief?
Yes.
And is this your signature on page 592 at the bottom? Yes. Okay. Do you adopt your witness statement as your evidence in these proceedings? Do
Can
you
you repeat,
accept?
please?
Do you accept your witness statement as your evidence?
Yes.
No further questions.
Thank you.
Sorry. Can you repeat the last question again?
Sorry, I am saying, do you accept that your witness statement is your evidence in this case?
Evidence. Sorry, I don't understand this question.
Okay.
I think I don't understand this question.
No problem. You are making the statement which runs to 2 pages. And I just want to know that your statement is going to be used as evidence in this case. So do you accept it?
This is my statement.
Okay. No further questions.
Thank
Okay,
you, Ms. Khan.
Thank you.
Ms. Mani, who is the lawyer for the claimant, Ms. Denisova, she is going to ask you a few questions. Ms. Mani.
Let's try.
Hello, Mr. Dmitry Grigorev. Is that pronounced correctly?
Yes.
Yes. Hello. I just have a few questions for you, not too many questions. In your witness statement, you have said that you paid for your shares in the company in Realist. Can I ask how you paid for those shares and to whom you made that payment to?
I make it by bank transfer to Aleksei.
To Alexei's personal bank account?
Yes.
Okay. Did you put evidence of that in your witness statement? Because you've made a statement to say that you've made a payment. Is the evidence of that bank transfer attached?
It's a hard question for me. I don't understand it in English.
Sorry, I will ask again.
Sorry.
Ms. Mani, I think we have the witness statement in front of us, and I think we know what's attached to it and what's not attached to it, and we can see for ourselves. I think it's important that we keep the questions limited to what the witness can answer, particularly because he has said that I don't want it to be too challenging for him. English is not his first language, but you can make submissions on whether there is any exhibits lacking to Mr. Dimitri's witness statement.
No problem. Thank you, Your Honour. Mr. Grigorev, did you sign a document called an instrument of transfer that allowed the shares to be transferred to you? Did you sign something for the transfer of the shares, a legal document?
Did I sign legal documents about my shares?
Yeah, to transfer the shares from Aleksei to you. Was there a document that you signed?
I remember that I paid. I don't remember about sign, but maybe it was a long time ago.
No problem. Okay, you then say that Miss Denisova, she did not pay for the shares. How do you know this?
I know that she did not pay for the shares.
How do you know this? What evidence do you have that she did not?
I just know that she not paid.
Okay. Okay, you say you are the secretary of the company. Is this correct?
Secretary, yeah.
Company secretary, this is your role?
Secretary of Realist Holding.
Yeah, this is your job. Okay. You say that you've reviewed the company documents and you cannot see any evidence of payment. Is this correct?
I did not see that she paid.
Okay. From the company documents, in the company documents, you cannot find any evidence of payment.
In company documents, I cannot find.
Okay. When you paid for your shares, you paid to Mr. Galtcev. You paid to him direct. You did not pay to the company, correct?
I make bank transfer.
Yeah, to the owner of the shares, right, Mr. Galtcev? You paid him direct to his personal bank account, not to the company account.
Yes, I think I have confirmation from the bank.
Okay, so there would not be any evidence. Let's start again. Would there be any evidence of the payment from Anastasiia in the company records if she made the payment to him personally?
I don't understand, sorry. I don't understand this question in English.
Okay, I think you can make a submission on that. I think you've asked Mr. Dimitri what the position was with his payment.
Okay, no problem. Okay, just a couple of more questions. As the company secretary, did you register Anastasia's shares on the DFC portal after the 30th of January transfer? So on the 30th of January, there was a transfer document. Then somebody went into the DFC portal to register the shares. As the company secretary, did you make that registration?
It's I don't understand it too, sorry.
Okay. You are the company secretary. Did you, on the DFC portal, did you register Anastasia's shares after the 30th of January?
I think I don't understand this question clearly because my English is not good.
No problem. Do you have access to the DIFC portal?
Do I have access to a DFC portal?
Yes.
I think yes, I have.
Okay. So do you, as a company secretary, do you go in and make changes inside the portal? Like, for example, shares coming on, shares coming off, changes in the DIFC registry. Who makes these changes?
I'm sorry, I don't understand. It's too hard.
Okay.
My English is not good.
Okay. Okay.
Let me try and help. Mr. Dimitri,
Sorry.
you are the company secretary of Realist Holding. Is that correct?
Realist Holding, yes, secretary.
Right. And as the company secretary, you have a role in the company documents and making sure that the DIFC companies register is up to date. Is that correct?
If I understand you, you ask how these transfers are.
No. What do you do as company secretary? Why don't we start with that, Mr. Dimitri? I'm so sorry, and let's take this very, very slowly. I think Miss Marnie wants to ask you about your role as company secretary, and we don't want this to be confusing for you. So let's just start with that, and then I'll hand back to Miss Marnie. What do you do in your role as company secretary of this DIFC registered company?
It's hard. My lawyer always helped me with all these tasks.
Right, Miss Marnie, back to you. You have
Thank you, Anna.
Part of an answer, which may take you further to get back to your question, but you're going to have to take it step by step.
Okay. Okay, I'll try again. So who would have registered Anastasia's shares in the DIFC portal? Would you do that, or your lawyer would do that?
I didn't do it. My lawyer helped me with it. My lawyer did it. I did not do it.
Okay. Okay. So
I understand it right.
Okay. Yeah. No, that's fine. That's fine. I've got what I needed. Okay. So as your role as company secretary, when you discovered that the payment had not been made, in your opinion, did you issue a notice for non-payment? Did you ever say to Anastasiia, you have not paid, please pay?
Did I say to Anastasiia, please pay?
Yes.
I did not say it.
You did not say it. Okay. Did you? So you knew that she had not paid, but you never asked her, why have you not paid, or when can you pay?
I know about it later.
So you found out that she did not pay later.
Yeah.
Okay. What date did you find out that she did not pay?
I don't remember right now.
Okay.
I
Would
think
it be before or after she transferred the shares?
can you repeat?
Did you find out that Anastasiia did not pay for the shares before or after she transferred the shares? To Dimitri.
Before or after.
Yeah.
It's
So,
not. It's hard. Sorry, it's hard for me.
okay.
I don't understand it in English. Sorry.
Sorry, Your Honour, you're on mute.
Sorry, transferred the shares to who? To Mr. Nicola?
Yes.
Do you want to try again and be more specific?
Okay, I will try again, Your Honour. Okay. When did you find out that Anastasiia had sold her shares?
That she sold her shares?
Yes.
Aleksei said me.
Aleksei told you, okay. And
Yeah.
when Aleksei told you, at that point, did you know that Anastasiia had not paid for her shares? Or did Aleksei tell you that she had not paid for her shares?
Aleksei said me.
Aleksei told you that she had not paid for her shares.
That she not paid.
Okay. So this was at the same time he told you Anastasiia is selling her shares and she has not paid for the shares.
I don't remember.
Okay.
I don't remember the exact time.
Okay. Thank you. Thank you, Ms. Dimitriov. That's all I think. It's very difficult to ask any questions. Okay,
Yeah,
thank you for your
sorry
time.
for this.
No problem
Thank
at all.
you.
No problem. Thank you.
Thank you very much, Ms. Moni. Ms. Khan, do you have any questions in re-examination?
No, Your Excellency, it's okay.
Thank you very much, Mr. Khan. Thank you very much indeed, Mr. Dimitri. Thank you for giving us your time today. Your evidence as a witness is now complete and you can stand down. And Ms. Khan, I think it's time for you to call your next witness, Mr. Kuchin.
Hello.
Mr. Kuchin, am I pronouncing your last name correctly?
Yes, correct.
Thank you. Thank you for appearing here today. Firstly, you will be sworn in as a witness to swear that the evidence you're giving is truthful. And I will hand over to the registry now to complete that formality.
Thank you. Please, can I confirm whether you would prefer to swear on oath or by affirming? So if you swear on oath, you will be swearing on the Holy Book. And if you're swearing by affirming, then you are swearing that you will be saying nothing but the truth without the Holy Book.
In both cases, I should just emphasize, you will be swearing that you are telling the truth. What the difference is whether you're swearing on a holy book or not swearing on a holy book. That is the only difference. If you are swearing on a holy book, it's an oath. And if you were swearing without a holy book, it's an affirmation. And it's your choice, Mr. Kuchin.
Okay.
Would you like to swear on a holy book or without a holy book? You would have to have a holy book with you, such as the Bible. It may depend on what you have to hand, but which is your preference?
Your Excellency, he does not speak English.
Yes, my English is very bad.
Right. Well, can I just say, Ms. Khan, I think in future, if we're going to have witnesses appearing before the court on the basis that their witness statements were written in a different language and then translated, that it's incumbent on the party presenting their evidence to provide an interpreter.
Absolutely, I understand, but like I said, that I had no instructions in the sense you can say that I have come in the picture at the last minute.
Well, certainly, but perhaps you can tell your co-counsel or whoever the other lawyers are who were involved in this matter before you were instructed that that's an important part of giving evidence. It doesn't make sense if we have a witness statement translated into English without a witness that doesn't speak English appearing before this court without the benefit of an interpreter. The whole system will fall apart then, because we won't be able to understand the witness's evidence. Are you saying Mr. Kuchin doesn't speak any English whatsoever?
I would say that we would be in a worse position compared to the previous witness, and I have never spoken to this witness, but when I was informed that he cannot speak English, then I said you should have arranged an interpreter, because this will look bad, and probably his statement will be struck off, because first of all, you should mention that this is a translated document. So the due instructions were given, but it was like I was on board more than 3 weeks ago, but formally retained recently. So I had access to the document, but the facts pertaining to the witness were known to me just yesterday. So I apologize for the same, and we can treat the evidence as a hearsay because the main witnesses were the ones, Aleksei and the claimant herself. And if it was in my hands, this would not happen.
Ms. Khan, that explanation is very helpful. Thank you very much indeed. Could you switch your camera on? I can't actually see you. I've got a blank screen. Ah, there you are.
That's the paper I kept.
Right. No, thank you for that explanation and for understanding what the procedural requirements are for this court, in the sense that, of course, we would need an interpreter for a witness that does not speak English. Ms. Marnie, how would you like to proceed? And I can just share, as I've already shared earlier during this hearing, Mr. Kuchin's evidence, so far as I can tell from this witness statement, is not directly relevant to the preliminary issue. So it's a shame you can't cross-examine him because you wanted to, but if we're focusing on what the highly material evidence is, I would not put this witness statement in that category. But Ms. Marnie.
Yes, Your Honour. I would just like to point out that there are 3 legal advisors on behalf of the defendant. Mr. Hussam of UAE Advisor from the outset, the law firm that is on record, which is also DIFC registered as Part 1 and Part 2 practitioners, and Ms. Khan, who's counsel for today. We have had ample time this morning, or since yesterday, when Ms. Khan identified that the language barriers to find an interpreter, which is very easy to find in the UAE. So that arrangement should have been made, but it's just indicative of the way that the whole case has been conducted from the outset. No procedural requirements or orders have ever been complied, which has made it our task very, very difficult. In relation to the material facts in the statement, I would have just asked the same questions. Who Mr. Kuchin paid? How did he pay? Did he sign an instrument of transfer? And how does he know that Anastasiia, because he's made a statement to say that Anastasiia didn't pay, and how did he come to find out that she didn't pay a person individually. The only other little material thing that I wanted to ask about was the video, the promotional video, which I know you don't have access to, but we can make that available. In the promotional video, Mr. Aleksei and Mr. Kuchin are sat together, and Anastasiia is introduced as a founding partner. This I know is not material to the preliminary issue of whether the shares were paid for or not, but it is material to the credibility of the statements and the flip-flopping and morphing of the position, you know, from the defendant's side. So those are the points I was going to make through the examination, but I can make those in my submissions. But I do request that these two statements are struck out if you know, if they are going to be relied on as hearsay.
Well, we're only talking about Mr. Kuchin's statement. Which other statement are you referring to?
So, yeah, okay, I accept that. Okay, we managed to get some information out of Mr. Gregorov, which is sufficient, but like you say, it's not that material anyway.
Yes.
I accept that. Yeah. So if Mr. Kuchin's, if the defense want to rely on Mr. Kuchin's statement, then I would request that it is struck out.
I don't understand.
Right.
Sorry.
Don't worry, Mr. Kuchin. Do not worry. This does not relate directly to asking you questions. You can switch your camera off for the moment, and we'll come back to you in a moment. Ms. Mani, I fully appreciate your position, and it is important that we have compliance with the rules of this court. There is a way that things are to be done, but we are where we are, and we need to be practical. I, for my part, am very focused on the preliminary issue. There are lots of other issues in this case, but I felt it was important that we deal with the key critical issue in dispute between the parties, from which other consequences flow. To the extent this case continues after the decision on the preliminary issue, we can certainly look at the video then, but I do not feel it's necessary to look at it at this stage, nor to deal with a lot of the evidence that's included in Mr. Kuchin's witness statement, which is not directly relevant to the preliminary issue, and even in relation to the preliminary issue. He says that Ms. Denisova did not pay for the shares, but it's just hearsay. I'm not sure it's going to advance matters much further, but I've heard you. Ms. Khan would like to say something.
Yes, Your Honor. Your Honor, Your Excellency, yesterday, I think yesterday my client sent an email to the Defendant's Counsel introducing me, providing my email ID as well as of my team. But we received no response from the registry as well as the defendant. Then I sent an email to the defendants asking them that would they be examining our witnesses, and if so, we could have scrambled to arrange an interpreter. I received no response. Then in the night, I sent an email to the defendants that I will be cross-examining their witness. And also, this is very strange that they claim that they did not receive the witness. But my first email to them, I pointed out that I have never come across a trial bundle prepared in this manner, which is going to make a judge's life so difficult and that of the witness. And this is not the way it should be done. And I gave a structured way how it should be done. And the current trial bundle is following that instruction. So how can you say you did not receive my email?
Ms. Khan, my focus at the moment, Ms. Khan, please let me finish. My focus at the moment is to make sure that we get to the end of the evidence and we focus on the preliminary issue. I understand your position. You were instructed very late in the day. I'm not sure that the day before the hearing is the right time at which to start raising issues on the trial bundle. I understand your point about the duplication in the trial bundle, but I have managed fine. It's extremely last minute. I don't know whether your email was received by the claimant's counsel or not, but I'm not going to arbitrate a dispute within a dispute about who lies at fault for where we find ourselves today, which is Mr. Kutchin about to give evidence and the court being told at the beginning of his evidence that he doesn't speak English. We did mention earlier today that Mr. Kutchin was one of the witnesses and this point was not raised, but my aim here is not the blame game, to blame anybody for why we're here today. My aim really is to make sure that we get to the end of this trial and we deal with the evidence appropriately, and that I have the evidence that I need to make a decision on the preliminary issue. So I suggest that we leave aside who emailed who, at what point the witnesses should have been notified to the other side. That is not my present concern. My present concern is what we do about Mr. Kutchin's evidence. I propose that we strike out Mr. Kutchin's evidence. I'm not convinced it advances the substantive issues any further. Do you have any comment on that?
Your Excellency, I believe that the rules provide that if the witnesses are not cross-examined, it can be treated as a hearsay evidence. So it could be treated as such, and there's no need to completely strike it off. Secondly, I do agree that yes, it's not so relevant to the point in question. The ultimate point is whether or not the cash was paid for the shares. And I leave it to the discretion of the court to decide on this issue. But as such, because considering the fact that the documents were not shared in the way that was expected or prepared in the way that was expected, the defendants do stand a chance that whatever evidence has been submitted should be recognized by the court to the extent possible.
Sorry, what do you mean the documents have not been prepared in the way that they were supposed to be? Could you clarify that?
I mean, ideally speaking, a witness statement should be prepared in response to the statement of the witness statement provided by the claimant. And if he has any supporting document, he could get a letter from the other defendants supporting the contention of the defendant and submit it as exhibits instead of a witness statement in a witness statement. So these are things that could be generally overlooked by lawyers who are mostly local lawyers and who do not have DIFC experience. So that is something that has been done, and there is nothing I can do at this stage to undo it.
But Ms. Khan, you're talking about the first defendant's witness statement. We're not talking about the first defendant's witness statement. We're talking about Mr. Kutchin's witness statement. So I'm getting a bit confused. Talking only about Mr. Kutchin's witness statement.
The problem is that Mr. Aleksei introduced the witness statement of Mr. Kutchin as his exhibit.
Right. But we've sworn it in as if it's a fully fledged witness statement. Are you saying
Yes.
that if he had not done that, then we might have had an indication that in fact he doesn't speak English and that this was actually a translated witness statement? Is that the point you're making?
The point is that what I'm trying to say is that the problem is that we could have had this exhibit, this witness statement as an exhibit. But now, having said that, this is done, and only thing is that I don't want but the client has now given me instruction that they're fine having it being struck off. But
okay. Right. Okay. That's very helpful. Thank you very much indeed. Sorry, Ms. Mornay, you looked like you wanted to say something. Do you have any final point on this? I should just say that I'm minded to strike off this witness statement. I don't feel it advances the issues much further, and the defendants have now agreed that that's an appropriate course of action. So I think that we've reached a landing on this issue, but you did look like you wanted to say something, so please do speak up if there's something further.
I feel that the court has reached the right conclusion. The only point I was going to make, which is now redundant, was Mr. Kuchin can't even confirm what is written in his statement because he can't read it, so it would be pointless anyway. So, but the court has reached the right conclusion, and thank you very much for your honour for that.
Thank you. We are all agreed. Now on the record, we have the evidence of the claimant, the evidence of the first defendant, and the evidence of Mr. Grigorev. And we have now reached, I am striking off the evidence of Mr. Kuchin. Mr. Kuchin is free to go, doesn't have to stay at this hearing if he does not wish. And we have now completed the evidence. What I suggest we do is have a short break for counsel to collect their thoughts for closing submissions. And my next question to you both is how long you would need, how long a break you would need before we can come back, have closing submissions, and bring this hearing to a close. So I'll start with you, Ms. Marnie.
Your Honour, would 30 minutes be okay, or is that too long?
So it's 2:13 p.m. For me, 30 minutes is absolutely fine. Let me ask Ms. Khan how long she feels she needs and if 30 minutes sounds suitable.
Your Excellency, 15 minutes is also enough. We can then wrap it up sooner. But I believe one more thing again, I don't want to again appear to be cribbing and complaining, but if the defendant's counsel has sent a video recently, I was not marked to it. So I believe that after I appeared, they should at least take the courtesy of finding out that why they cannot send me an email.
Why don't I leave you both offline? You can discuss who received emails and when or didn't, and whether or not that matters now. But that is not my current concern. You're talking about the video. The video actually is in the trial bundle, but of course, given the format of the trial bundle, it's not visible. So it may not have been sent to you directly. I think the point is it was one of the files relied upon by the claimant, but did not translate into the trial bundle so that I could view it, but I don't think it's necessary for today's purposes. I think we're agreed on 15 minutes. Is that acceptable to you? I saw you nodding, Ms. Marnie. Yes?
That's acceptable.
Certainly. It's now 2:14 p.m. We will reconvene at 2:30 p.m. for closing submissions. Thank you very much indeed.
Thank you.
Thank you.
Right. Welcome back, everybody. I think we're ready to hear the claimant's closing submissions.
Thank you, Your Honour. Is there still an echo? No, it's gone.
No.
Okay. So, Your Honour, today's hearing concerns the preliminary issue, which is a straightforward but critical question: whether the claimant paid for paid $1,000 for 10,000 Class A shares in released holding. Just to go through the background, on the 7th of January, the defendants passed a resolution to allocate the shares to the claimants. This fact is not in dispute. The first defendant has then confirmed in his oral witness evidence today that this payment was due to him personally, and he was expecting this payment into his personal bank account. On the 23rd of January 2024, then the claimant submits that she paid the $1,000 in physical cash to the defendant at the DIFC office following a business meeting. There is no
Ms. Marnie, you're going very fast for me.
Okay, sorry, I do talk fast. I need to slow down. Okay, I'll slow down.
If you could slow down, that would be very helpful for me. Thank you very much indeed.
No problem. I'll start again. Just from the factual background, on the 7th of January, the defendant.
Oh, no, I've got that. I did manage to keep up, but going forward, if you could, I tell you where I lost you. Yes. The first defendant was expecting payment personally in his bank account. Let's continue from there. Thank you.
Okay. Then on the 23rd of January 2024, the claimant submits that she paid $1,000 in physical cash to the defendant at the DIFC office following a business meeting on that day. There is no dispute of fact relating to the fact that the parties met on this day. And the defendant has confirmed this in his oral evidence, that there was a meeting scheduled on that day. So as this payment was due to the first defendant, a receipt from the company was not required, nor was any company documentation required. So a few days after this meeting, a pre-filled form called an instrument of transfer was left on the claimant's desk, which she duly signed and returned to the first defendant's secretary. The instrument of transfer was dated 30th of January, the contractual date for the transfer of the shares. The instrument of transfer contained a very clear receipt that states, I, Aleksei Galtcev, for good and valuable consideration of $1,000 provided to me by Anastasiia Denisova, hereby transfer to the transferee 10,000 ordinary Class A shares. The first defendant and his secretary then countersigned the transfer deed, and the claimant's shareholding was duly entered into the DIFC public register, either by the company or the company secretary, with the contractual date being 30th of January. We submit that the reason why the first defendant did not check his bank account for payment for over 4 months was because he knew he had been paid in cash. There was no reason to check the bank account. On the 1st of June, when the first defendant discovered from the buyer, Mr. Nikola Kustik, of the share sale, having been taken place on the 27th of May, the defendant became discontent. On the same day, he vocalized his discontent about selling the shares to an existing shareholder in a subsidiary company without first taking his permission. For clarification, Mr. Nikola Kustik, who's the buyer, is a shareholder in a subsidiary company that is owned by Mr. Galtcev.
Sorry, what were you saying about commission? I missed that. So Mr. Nikola,
Yes.
who had entered into a share sale and purchase agreement with the claimant,
Yes.
was an existing, because this came up in the evidence, was an existing shareholder in another company.
That's right. Yes. Mr. Nikola Kustik is a shareholder in a related company.
What did you say about commission? You said something about commission.
Commission?
Unless I misheard you.
No, sorry, that must be a mistake. Sorry, okay. No commission. Permission.
Sorry, what did you say about permission? I missed that.
Okay, so on the same day, the defendant vocalized discontent that Anastasiia had sold her shares to Nikola without his permission. This is set out in a WhatsApp message where he says, I will read from the message. If you sell to outside people, there is no question. When you sell shares to people that the company paid for, and I spent a lot of my time, and you don't ask me for my opinion about selling your shares to these people, this is very rude. So he was upset about the sale to Mr. Nikola Kustik specifically. He was not upset about selling the shares to a third party, an outsider. This is in his WhatsApp message, page 116 of the bundle 112 and 116 of the 112 in red and 116 in green of the bundle. So on the same day, again, on the 1st of June 2024, the first defendant sent a WhatsApp message to Anastasiia, the claimant, to say, I will recommend to Nikola to reverse the deal. There is a clear motive here to deprive the claimant and potentially the buyer, Mr. Kustik, of the shares. The first defendant's objections to the share sale morphed over a period of time as evidence from his WhatsApp messages and official conduct. First, he finds out about the shares to an existing shareholder and raises the initial objection about selling the shares without his permission, which I've already covered. That was on the 1st of June. Then on the same day, his position shifted and his complaint was around misinformation to the buyer. But obviously this is not a legal ground on which he can deny the share transfer. Then he texts her to say, if I were you, I wouldn't spend the money. He's clearly evidencing his intention here to sabotage the share sale. This was all happening on the 1st of June. We submit that he finally recalls that as the payment was made in cash, he has a lawful reason to object to the share transfer that cannot be evidenced either way. This was on the 3rd of June, 2 days later. So upon receiving the formal notice of the share transfer on the 3rd of June, the same day, he passes a resolution to state that the shares were not paid for and deregisters the claimant shares from the DFC company on the 3rd of June. One day after, on the 4th of June, he raises the issue about non-payment and advises the claimant that he has already deregistered her shares. There was no notice of non-payment. This completes his objective, that his conduct completed his objective for the share sale to the existing shareholder to be sabotaged, to not proceed, and to deprive the claimant of her property as a personal vendetta. Critically, the defendants never marked the shares as unpaid in the company registers, never recorded any lien over the shares, never raised the issue of non-payment until after learning of the share sale agreement, never raised the issue of non-payment when he fired the claimant in May as per his oral evidence. Surely that would be the first thing you would do when you fire an employee. You haven't paid for my shares, well, you need to pay for these. He never raised the issue of no right to sell the shares to the buyer on the basis of non-payment. When he spoke to the buyer, he did not say, you are not entitled to these shares have not been paid for. He proceeded to register the transfer with the DFC Public Register without any objections. He treated the claimant as a shareholder for 4 months, including in external and internal marketing materials. He introduced her as...
You're speeding up again, Miss Marnie, I'm so sorry.
Sorry.
Let's go a little bit more slowly. Thank you.
Okay. Shall I recap the last paragraph, the last part?
Yes, why don't you do that? Yes, thank you.
Okay. So critically, the defendant never marked the shares as unpaid in the company registers, never recorded any lien over the shares, never raised an issue of non-payment until after learning of the share sale, never raised the issue of non-payment when he fired her in May as per his own oral evidence. Surely when a relationship is terminated, the first thing that a CEO of a company would do is to look at the financial position of who owes what to whom and record that on the official correspondence. He never raised the right to sell the shares because of non-payment to even the buyer. To the buyer, he mentioned misinformation, company problems, this, that, the other, but not that she does not have the right to sell the shares because she has never paid for them. He treated the claimant as a shareholder for 4 months in external and internal marketing materials. He registered her on the DFC Public Register without any objection. He introduced her as the founder and CEO in any meetings that she was present in. So the first defendant's conduct and timing reveals his true motive, which is retaliation, not a genuine concern over payment. Had the defendant had a lawful reason of non-payment Had the non-payment been a lawful reason to deprive the claimant of her shares, then surely the defendants would simply just demand the payment on 14 days notice or even 1 day's notice. Even if the first claimant had been forced to pay twice for the shares, 1,000 that she says that she paid in cash, another $1,000 that she pays through the bank account upon demand, she would have paid the sum of $2,000. The share sale was for $200,000. That would have given her a profit of $198,000. There was no logical or commercial reason for her not to pay it twice. She still would have been in profit. But she was deprived of that opportunity to even make the payment. Her shares were deregistered before even being given the opportunity to rectify the alleged mistake or non-payment. She was forcibly removed from the shareholding. She was deprived of her property. She was forced to become in a position of breach of contract with the buyer. she had to return the funds, the $200,000 to the buyer. So under no circumstances has the defendant's conduct been reasonable. In fact, it has been lawful. The defendant's case is procedurally defective, commercially illogical, and unsupported by the evidence. Therefore, we respectfully ask the court and urge the court to find that on the balance of probabilities that the claimant did pay the $1,000 for the shares, the claimant's shareholding was duly constituted, and the revocation of the shares was unlawful and in bad faith.
Thank you very much, Ms. Marnie. I do not have any questions, but it may be helpful for me if you can just, and you don't have to do this now, you can do this while I'm hearing from Ms. Khan, but just the references of the notices that you mentioned, the formal notices on the 3rd of June. I've just looked, I know they're in the bundle, but to save me time looking for them, it will be helpful to have the references. You can give me the references in the new bundle or the old bundle, that's fine. Just tell me which and I can look them up. I've seen them, but I just want to be reminded of the references.
Certainly, I will find that for you.
Thank you. While you're having a quick look, but I don't want you to not have an opportunity to hear Ms. Khan's closing submissions because that's also important. I'll just give you a moment.
Your Honour, I will ask my assistant to help us find that.
Wonderful, wonderful. Okay, thank you. So we'll move on directly then to Ms. Khan's closing submissions on behalf of the defendants.
Thank you, Your Honour, my learned colleague. This is the closing submission of the defendant. And this matter turns on a very single and determinative question. Did the claimant pay USD 1,000 in cash for the 1,000 shares she alleges to have acquired in Real Estate Holding Limited? This is not an issue whether the shares were revoked. This is not an issue whether she was given adequate notice. This is not an issue right now to decide whether she was punished for selling her shares. The defendants submit that she did not pay for the shares. The claimant's case is stripped of assertions and assumptions, consistently maintaining that the claimant's case is a strip of assertions and assumption and is unsupported by any reliable evidence. In contrast, the defendants have consistently maintained that no such payment was ever made, and they have produced witness and documentary evidence and even established in the cross-examination that corroborates the position. On the issue of proof of payment, the claimant confirmed in her cross that there was no receipt, there was no bank record, there was no exchange slip, or no email or written confirmation to evidence the alleged cash payment. Her reliance on Exhibit AD7, a cash slip issued to her husband, evidences that the company does issue receipts for small value transactions. It is to be noted that a payment which is received for share transfer pertains to the company. Perhaps in the process of translation, it has come to the situation that it is assumed that he is taking the money in his personal account. But if you see the timeline, first the claimant claimed that the payment was made on 30th January. Then she revised the account to 23rd January. And then the claimant contended that she paid cash around 23rd January after meeting with the investor in the office of the defendant. The defendant confirmed that he did not meet her in the office as alleged by the claimant, while the transfer instrument was dated 30th January. The logical question is that why would a person pay cash in advance without an instrument transferring the shares to her? Therefore, I can say that she did not pay for the shares. Secondly, on the issue whether the first defendant received the alleged payment in his personal bank account, the logical sequence would be that he would first physically receive the cash, then take deliberate steps to deposit in his personal account, following which a bank notification would be generated. It is entirely implausible that to suggest that an individual would fail to notice a message alert on their mobile in such circumstances, especially when it pertains to the bank account.
Ms. Khan, can I ask you a question?
Yes.
If he did receive cash, $1,000, why could he not spend it? Why would he put it in his bank account? It's possible because cash is can be spent anywhere.
Your Excellency, first of all, this money pertains to share transfer, and he is not the only shareholder. So obviously, if he has received the money, it has to go to the company account. So probably in the cross and during the lack of communicating in English, that would be a problem that he really did not understand the relevance of this question. But if a person, if he's a sole shareholder, I could understand that he could pocket the money and keep it and spend it and do whatever he liked. But if you have other shareholders and if you have received the money, you cannot take the money and spend it for yourself. It has to go in the...
Yeah. I'm so sorry to interrupt you, Ms. Khan. Please excuse me. So he was not the sole shareholder up until the 7th of January when a resolution was passed to sell shares to all these people. Is that correct? Because
yes, because
sorry, go on.
Sorry, the document which was produced by the claimant evidences that there were other shareholders who received in the resolution that was mentioned, there were other shareholders who would be a part of the whole group. So 7th of January, the resolution was passed and she alleges that she paid on 23rd. So obviously, you know, in the meanwhile, maybe the other shareholders have come on board or whatever it is, but the intention is that he's not the sole shareholder. So if you receive that money, you cannot pocket it. You cannot be treated as a personal account because then you turn around and say that everybody paid. So it's a big question that how you cannot pocket it, put it and spend the money. So, and the most important thing is that the claimant's contention in page 35 of a bundle, that is a particulars of claim, she is saying, and even right now in the closing, they are saying that she was not afforded. But of course, now in the closing, they are saying she could pay it again the second time. But so far, it was always one statement saying that she was not afforded the opportunity to rectify the non-payment. These are exact, precise words. These words are relevant because the very assertion that the payment notice should have been served is an admission that the shares were not paid for.
We just need to pause for a moment for a couple of reasons. Firstly, the first defendant has raised his hand, but he's not giving evidence anymore. And he needs to address the court through you, his counsel. So he may wish you to say something on his behalf. The second point is I'm trying to find my copy of the trial bundle, but I had understood from the instrument of transfer that the shares had been purchased from the first defendant, which is why I understood the payment was being made to him. I don't know if there were other shareholders, but certainly the shares that were being purchased by the claimant were being purchased from the first defendant. Why don't we take a moment, because it may be that that's what the first defendant is trying to tell you. Why don't we pause and you can take instructions, because I want to make sure that we have the correct position before the court, and I can check the instrument of transfer or somebody could share it. I'm going to ask Ms. Mani to share it. While she does that, Ms. Khan, I'm very happy to give you a moment to take instructions from your client, the first defendant, because it's important that he does have an opportunity to raise anything he wishes before the court.
Your Excellency, the fact is that he wants to come and speak and say something because he wants to show an email dated 16th of August where the claimant is lying about the payment. And she said that, you know, he wants to come.
Before we go into that, yeah, Ms. Khan, it's too late to have evidence on the preliminary issue at this stage because we have finished the evidential part of these proceedings for the preliminary issue. We won't be able to adduce any more evidence at this stage. Why don't we, in case there's anything else he wants to tell you that's relevant to the point you just made, Ms. Marnie, why could you assist the court and simply just pull up the instrument of transfer if it's not too much trouble, so that we can just be absolutely clear on this point and make sure that there's no misunderstanding?
Certainly, Your Honour. I'm just trying to find it.
Meanwhile, can I just make a call?
Sorry, Ms. Khan, what was it you were saying?
I just can I make a call to the counsel of the defendant to receive instructions?
Sure, absolutely. Let's take a break of 5 minutes. And actually, in the meantime, Ms. Marnie, you can find the instrument of transfer, and then Ms. Khan, please be ready to address this point as well. I don't want there to be any misunderstanding on this point. Thank you. We're taking a 5-minute break.
What is the point you are seeking to be addressed?
I think the point you were saying is that when the defendant received payment, he was going to have to share it with other shareholders. My understanding is that what was being purchased was his shareholding, so there would be no need to share any purchase price for the shares with anybody else. That was my understanding, and I want to make sure that that's not an incorrect understanding.
Absolutely. What I believe, yes, he was the sole shareholder before, and then he transferred the shares to other shareholder. Now, this is not established that when they came on board, because the resolution was signed on the 7th, and the claimant comes in the picture way back end of the month. So it is possible that the other shareholders have already come on board. So I believe that when you receive the money which pertains to the company, you cannot keep it then.
I think it's his shares, his personal shares in the company that were being purchased. But why don't you take instructions, by all means, raise this point with your client and co-counsel. It's 2:54 p.m. We will come back at 3 p.m. Thank you. Sorry, Ms. Marks, your hand is up. Is there anything else you need to say before we adjourn and come back?
Just to let you know, it's page 66 in green, page 72 in red, which is the email of the 3rd of June where Anastasiia notified.
72. Yes. Thank you so much.
Okay.
Thank you so
Actually,
much.
we're saying now, so you're saying 79, sorry. 79 and 85, sorry.
85 red. Is that correct?
85 red, yes.
Yes. Thank you. Right. Well, I'll see you all in 5 minutes at 3 p.m. Thank you. Well, welcome back, everybody. Miss Khan.
Shall I continue?
Yes, I just want to resolve this issue about whether the money that was paid to the defendant, the first defendant, was for the sale of his shares.
Yes, it was for the sale.
It was,
yes.
Right? Okay,
yes.
Thank you. So we've clarified that. We can, and it says here he was a sole shareholder and he sold different portions of shares to the different people mentioned as transferee on this document, correct?
Absolutely.
Wonderful. Okay, we can stop sharing then. Thank you very much for putting this up, Claimant's Counsel. And we're back to your closing submissions. Thank you.
Thank you. To end, to carry on with the last statement I made, and we ended on the issue that a statement was made that it is possible that the first defendant could have received the money and he could have spent it. Your Excellency, this is an assumption and it is not backed by evidence. It is very clear that the claimant did not pay. The fact that they admitted in the particulars of claim that they were not afforded 14 days notice to rectify the non-payment is very relevant. It is an admission that the shares were not paid for. And
Ms. Khan, why don't you take me to the particulars of claim? Because I don't recall when reading them, reading that reference to the 14 days notice as an admission. but I may be mistaken, but I think if that's a point you're going to make, then it would be helpful to see specifically how that admission was made.
Yes, I could take you to the page.
Yes.
Just a minute.
Thank you.
Thank you. I'm trying to open the trial bundle of 1,422 pages. It's just taking time.
If that's taking time while you're waiting for it to open.
I'm done. I'm done.
You're there? Okay, excellent. Ms. Khan, any luck?
Just, I'm at the, 1 second, I'll share. Okay, here it is. Just share. Sorry, it's paragraph 32, not 35, where they're referencing the 14 days notice. Here, the second defendant is a corporate entity owing a duty to the claimant. Article 12 requires the director to register the share transfers, necessary conditions are made, provide notice within 14 days to do that. And that is what it says that, and the 14 days is mentioned consistently to pay the amount, even in paragraph 35 here I found out. That the director should issue a formal call on the shares, provide at least 14 days notice to pay for the outstanding amount. The fact is that you are alleging that this 14 days was not provided to you to pay the outstanding amount, it means you did not pay the outstanding amount. You did not reference this saying that I want to repay it again the second time. You did not say that. So it means
Right.
that you...
I understand. I mean, I don't read it the same way as you. I read it as simply just a reference to the requirement of various articles in the Articles of Association and the company's law. I don't read it as an admission that payment was not made, but I take that's your argument. I understand it now, even if it's not something that I'm currently finding persuasive. Unless there's anything else you want to say on it, I think we can move on.
Okay, fine.
Thank you.
Thank you. Now, on the instrument of transfer, Your Excellency, the claimant relies on a pre-filled transfer, but the language good for valuable consideration is a boilerplate, and it does not constitute independent proof of payment, just like the analogy I provided. It's the share transfer document issued to all shareholders and not a receipt. And it is a mandatory requirement to mention that it is sold for consideration that has been received. Again, I would humbly remind the court of the analogy of the employment issue. Saying that the payment is made is not enough. Proof of payment must be provided. In the cross-examination, we established that a genuine shareholder would be expected to act in a manner consistent with ownership. Yet the claimant did not request a receipt or a share certificate or even a transfer document or resolution until April 2024. The attempt to sell the shares even without holding the share certificate. Further, the claimant failed to respond that when Mr. Aleksei expressed his view that on the telegram message 17 May, page 446 of the bundle, that no payment has been made. And she did not respond to it at all. And she admitted in the cross-examination that the first thing she thought that she should go and meet the lawyer. So this silence to the response for a direct assertion speaks volume. The defendant acted lawfully and within their rights. The claimant failed to fulfill the fundamental condition precedent, that is the payment. Her argument is that the defendants who are required to give 14 days notice is misconceived. If you buy something, you have to pay for it. You don't need to have notice, or somebody should not remind you, pay for it, or you should not be notified. It is a common assumption that if you are buying something, you have to pay for it. In the case, the shares were never perfected. It means that no payment was made for the shares, the share register was not updated, no share certificate was issued. The burden of proving the payment lies with the claimant, and it is not for the defendants to prove negative. The claimant has offered no persuasive explanation for the absence of even a basic receipt or a third-party confirmation for the so-called cash transactions she described. Her claim is just based on assertion, assumption, and not evidence. In conclusion, Your Excellency, the defendant respectfully submits that the claimant has failed to discharge the burden of proving that she paid for the shares. Her own account is inconsistent, unsupported, and contradicted by the totality of the documentary record. Accordingly, the defendants invite the Honorable Court to determine that no payment was made and the revocation of the shares was both justified and lawful. Of course, this is not a part of the proceedings to be decided upon in this hearing, but the fact is that no payment was made. The defendants further reserve their right to seek costs for the proceedings. Thank you.
Thank you very much indeed to both counsel for their helpful assistance during today's hearing and for their closing submissions. I am not in a position to issue now my decision on the preliminary issue. I need to think about it a little further and consider carefully everything that I have heard today. I will issue a decision as soon as possible, but I want to highlight to the parties that the reason I felt it was important to determine the preliminary issue before going any further with these proceedings is because it is the critical issue at the heart of these proceedings. If the shares were not paid for, there will be certain consequences. If the shares were paid for, then it seems to me that the pillar on which the defence is based will disappear. And it will follow that the claimant would be entitled to the shares. Therefore, once the preliminary issue has been decided, I think it would be helpful that the parties take that decision and see if they may be able to find an amicable resolution to this dispute, whatever the decision is. They will have an idea of what the decision is on the critical issue underlying these proceedings, which will have a substantial impact on how the proceedings may continue. I note that there were attempts at ADR previously. I've seen that in the trial bundle. But ultimately, the benefit of having a preliminary issue is that it narrows the issues in dispute between the parties, whatever the decision is. So I would like to encourage the parties to consider that. And I am considering, when I make a decision on the preliminary issue, including a provision providing for the parties to explore some alternative dispute resolution settlement mechanisms and require counsel just to send a short note to the court if no settlement is reached to confirm that there have been some attempts at ADR. Now, I just want to pause there to see if there are any comments from counsel in relation to my proposed direction. Let's hear from the claimant first, please.
Yes, Your Honour, we would be happy with that. To attempt ADR after we have received your preliminary decision. We have attempted that previously and attempts of settlement failed. We've also put a Part 35 offer in as well, and that was rejected. So at all stages in the process, we have tried to settle prior to getting to this point. And just whilst I have the platform, I would like to request that we are able to submit an updated skeleton argument just to recap on the points, because things have changed since our original skeleton argument was submitted prior to the hearing. If Your Honour would allow that, we would just like to submit a further skeleton argument just to recap the points that were covered today.
Right. I'm going to pause for a moment. Let's hear what the Defendant's Counsel has to say on both of these issues. Ms. Khan.
I mean, we do agree for the ADR, and we had proposed this, but you know, there are many factors that the claimant did not take into consideration regarding the cost she had or the damages she had in mind. And the only way a mediation fails is when the expectation is too high compared to the best alternative available. So we are again open to mediation. And when it comes to the written submission of a skeleton argument, again, yes, it would be to our advantage to prepare a skeleton argument which has been read out today, and nothing new to cover the skeleton argument into a closing submission, a written closing submission. a skeleton argument or an opening statement is what it is and not a closing submission. So I think the claimant's counsel should be very clear whether she intends to give a closing submission in writing or she intends to have the skeleton argument sent over, which should be sent over immediately because this is something you read in the morning and not something which you need to send after an afterthought or deliberation and treat it as a closing submission.
Right, I'm just going to pause there for a moment. Ms. Mani, I will come back to you. I see that you have your hand up. I just want to focus on the ADR point. And you raised the point, Ms. Khan, that it is important going into, say, a mediation, if that is the ADR option that is opted for there to be realistic expectations. And I just want to pick up on that point. In the claim form for this matter, the claimant requested that she wanted the 10,000 shares that on her case she paid for. Now, if the preliminary issue goes in her favour, one can see how she may have a good case in seeking the remedy that she sought in the claim form. As we see the case evolved, there were a number of other remedies sought, and I think it's important that if the case continues, if it cannot be settled, but also if the preliminary issue does go in the claimant's favour, I think it's very important that the DIFC law of remedies is carefully considered. There are issues such as foreseeability of damages. There cannot be double recovery. So, for example, at a basic level, if the shares were returned to the claimant, then she would have the value of the shares, as it were, and she would not be able to recover any alleged loss due to a failed transaction, which she say is because the defendants didn't give the shares to her. But I think it's very important in any event, if this case continues, that careful thought is given to the type of remedies, the quantum of remedies sought, and the how it complies with what the DIFC law of remedies is if the preliminary issue goes in the claimant's favour. I'm going to move in a moment to talk about this idea of skeleton arguments. Ms. Khan, it seems that you have a point to make in relation to the point I was just addressing.
Yes, Your Excellency, there's one point that I noticed that this claim was filed as Part 8 claim. And thereafter, in the claim form, I believe nothing was mentioned about the remedies as such. And then the court decided that the claim will be treated as a Part 7 claim. And then the question of the court fees and all that has to be taken into consideration. And the claimant also should consider that she can claim only whatever she has mentioned in her claim form, nothing more than that.
And, well, that's a point that you can make on submissions later. We're not at that stage yet. I'm just giving some views and guidance that may be helpful as this case moves forward. If the defendant, if this case continues and the preliminary issue goes in favour of the claimant, then the defendants can make points they wish to make about the remedies available. You're absolutely right that this claim was started as a Part 8 claim. I do believe that there were remedies sought within the claim form. Certainly you can check, but I recall reading the claim form yesterday and there was a remedy sought, which was, if I'm not mistaken, the return of the shares. But by all means, please do check that. Was there something else you wanted to say, Ms. Khan?
Absolutely nothing. Thank you.
Thank you. In relation, yes, Ms. Mani.
Your Honour, I just wanted to clarify, I meant to say, could we submit our closing submissions in writing, especially because I was speaking very fast. It'd be useful for the court to have it in writing.
I should mention I have no issue with closing submissions, and we'll hear from Ms. Khan, but I have been listening carefully and I will be requesting a transcript of today's hearing, and I will be rereading the entire transcript in drafting my judgment because that's my practice. So if that gives you any assurance that closing submissions are not necessary, I will make sure that all the points that have been made today by counsel and all the evidence that we have heard today is taken into account by me. Does that affect your request for closing submissions? I personally would not find them necessary if they're simply summarising today's proceedings, because I will be reviewing today's proceedings in the form of the transcript.
Yes, Your Honour, thank you. That alleviates my concern that you may not have caught everything that I said because of my speed of speech. So thank you for that.
Thank you. Okay, so I think we've dealt with, we don't need closing submissions. We've dealt with my proposal to include a provision on ADR. We've dealt with some of my thoughts as to what may happen in the future of this case, and if it continues for if the preliminary issue is decided in the claimant's favour, and if it continues, what remedies she may wish to how she wishes to plead her remedies based on what's been pleaded so far and based on the law. The final point is neither side submitted a schedule of costs, which is a requirement, I understand, for a one-day hearing. I think it's open to me to request a schedule of costs belatedly. And I'm just pausing for a moment. The registry can tell me if that's not something that's done, but I think it would be helpful if schedules of costs were submitted and they relate to the preliminary issue only. So it would be costs after the decision on the preliminary issue. Well, the case management order was handed down in relation to the preliminary issue. Yes, Ms. Khan.
Sorry, I mean, the only fact is that I do remember that is the statement of cost must be submitted before the hearing, and I attempted to do that, but I still note that the registry has not added me or shared the case file. But I will reach out to the registry tomorrow, and this is not something I should disturb you with. But the only reason I mentioned it is that it's not that something I have overlooked, and only I was waiting for the registry to add me or share the documents.
Yes, of course. Again, I'm not looking to issue sanctions for failures to comply with the rules. I'm just trying to navigate a way forward. I'm just checking the rules on immediate assessment and the schedule of costs. Just give me a moment. I'm sorry, you'll have to give me a moment. The section on schedules of costs is eluding me. We will deal with this with directions after today. And so the registry will issue directions if that schedule of costs up to and including today from the date of the case management order directing a trial by preliminary issue, if that's going to be necessary.
Thank you, Your Honour.
Are there any other matters we need to deal with before we adjourn? Yes, Ms. Khan.
Yes, I just wanted also to inform the court that nowadays, earlier when we were filing the DRC proceedings, yes, we had to share the schedule of costs. But then there came a trend where the written submissions were required to be provided, so it was not possible to assess how much time was spent for the schedule of costs. So that is the reason now at least the proceedings which I have attended, the schedule of cost is submitted after the closure of the written submission. But since you have decided that there's not going to be a written submission on the closing, we can submit the schedule of cost.
Right. Well, I can't comment on the previous trend, but my understanding is the current trend is that schedules of cost should be submitted on the day of a hearing if it's a one-day hearing. And in this case, we're not going to have closing submissions. So we will issue directions in relation to the schedule of costs. I will make a decision on the preliminary issue. I'm going to include a provision on ADR, and then I want the parties to think very carefully about their positions upon receiving the decision on the preliminary issue. And I think it will be helpful if good faith efforts were made to, with the narrowing of the issues and dispute between the parties, to see if they are able to eliminate or even narrow further the issues between them. Unless there's anything else that either of you would like to raise, I would propose that we now adjourn this hearing.
Thank you, Your Honour. Thank you.
Thank you, Your Honour.
Thank you again for your time. Thank you.